No. When it is filed? It was filed in the month of August. August, then what you are doing? You must not have removed the office objects. No, it's all complied. I'm seeking for stay of the. That is all right, but you did not move the court since August. It was raised it has come up here. Come up on board. For admission. For admission. So then where is it? Then date must have been given. So on the end of this month, date is given now. Then if you want to prepone the date, then file IA. I filed an IA. All right, list it on 2 days after 2 days. It may be listed after 2 days. IA.
My lord, may I make a submission, my lord?
IA will be listed on, today is what? 4th. 7th. IA will be listed on 7th.
My lord, may I make a submission, my lord?
Matter is pertaining to transfer.
One second. Yes, Mr. Raghavan.
My lord, there is a miscellaneous first appeal that we have filed, my lord. In a section 9 petition, the court has passed an ex parte order against us even though we entered appearance. And then, my lord, says maintain status quo when we have already invested 450 crores on the project. And, my lord, there are no reasons given, nothing in that order, my lord. My lord, I request that it may be taken up at 2:30, my lord. There's great urgency.
Not 2:30. Day after tomorrow. Will take.
My lord, tomorrow, my lord, if it's possible.
Tomorrow is what?
Tomorrow, my lord, is 5th.
It is.
My lord, there's great urgency. There's great urgency for us, my lord.
It is filed when?
My lord, it has been filed today, my lord. The order was passed on Friday.
What is day after tomorrow and difficult?
My lord, difficulty, my lord, is that our investment, my lord, at the instance of this seller, injunction order has been passed. I am the owner of the property. And it's status quo order, my lord.
Subject to removal of office objections tomorrow.
Grateful. I'm very grateful.
Office objection will be there, it will not be listed.
I understand. Very grateful.
My lord, this is matter pertaining to transfer, my lord.
Pardon?
Matter pertaining to transfer.
Transfer.
Yes, my lord. In single bench has erroneously allowed the petition.
What is the urgency?
The urgency, my lord, because in this judgment, my lord, neither the petitioner nor the respondent has been entitled, my lord. So it is against both. The judgment has been passed against both, my lord. Kindly have it on next week or next week, my lord. Next week, any date.
20th November.
Serial number 30, serial number 31, my lord. Serial number 31, my lord. The connected matters are posted on 25/11 of this month. May I request, my lord, this may be tagged along with the writ appeal 45 of 2024, my lord.
What do you want? We'll issue notice 6 days delay. Notice returnable on 27th November.
My lord, connected matters are on 25th, my lord.
25th November.
Writ appeal 45 of 2024.
No, we issue notice in this delay application.
Only government is the party.
Yes. Only government is the party.
Please, my lord.
Addition. 31.
Any other party is there?
The other respondents are the
31,
petitioners
31.
in the petition.
Any other respondent than government?
There are private respondents, my lord.
Then we have to issue, that is what, then we have to issue.
The writ appeal.
In that event, we have to issue notice.
My lord,
Since other parties have to be served in delay application.
my lord, they have also filed a writ appeal 145 of.
Maybe, but here it is delay of 6 days.
Please,
Returnable on 27th November.
my lord. Connect this matter along with the owner.
On that day you request. After it is, the delay stage is over. Yes.
25th. Number 75. Time for appellant.
75.
2 weeks time.
What do you want?
2 weeks time. Time for the appellant.
75, 2 weeks time. At the request of learned appellant, Mr. Bharat K. Stand over to 4th December.
May I make one submission, Lordship's kindly? 114, my lord, 114. It is listed for.
Yes, one second. Yes.
Sorry.
Number 85.
85.
And for the complainant, the respondent has submitted a copy. Passenger submitted a copy. And the main fixed date for hearing.
4th December. Yes, Mr.
My lord, 114, my lord, listed for final hearing. This matter, my lord, it pertains to the court officers' pay parity. The orders are passed, my lord, under the directions of the Honorable the Chief
Serial
Justice.
number?
114, my lord.
114.
Yes, my lord. The appellant, my lord, is the registry, and the orders are passed by the Honorable Chief Justice under the directions of the Honorable the Chief Justice, my lord, and the registrar has passed the order. So I'm praying, my lord, in case your lordship's permit may be posted before some other bench, my lord, because the administrative orders were impugned before the learned single judge who was having the special roster on the High Court matters, my lord. And then the Honorable Single Judge's order is now in appeal before your lordship.
You renew your request at 2:30. We'll just see what is the matter.
Grateful. Grateful.
Give me the papers. Yes.
Grateful.
Serial number party, serial number party, kind indulgence. Serial number 40.
What do you want?
I request my lord any date, any adjournment, seek for adjournment for the
Adjournment
appellant.
5th December.
Please,
40.
40.
40 5th December. At the request of learned advocate for the appellant, stand over to. What is this MFA? Miscellaneous first appeal.
This is first appeal,
How come?
arbitration.
For at the request of learned advocate for the appellant, stand over to 5th December.
Yes.
My lord, I am a party in person. I filed a PIL in this honorable court requesting for a PIL bench for Gulbarga and Dharwad. And on August 1st of August, this your lordship has come up with a very creative notification that you can be filed at the Gulbarga bench also. I already filed my first PIL at Kalburgi bench, my lord. I request permit me to withdraw this PIL file before this honorable court.
Not list. Whatever you want to withdraw, get it listed. Day after tomorrow. Day after tomorrow at 2:30.
I already filing the memo for withdrawal.
For withdrawal.
Yes, my lord.
Day after tomorrow at 2.
6 November. Much obliged.
If I may be permitted to make a submission. My lord, there's urgency in this matter. Else, last Monday, I received a 7-day opposition notice. The matter may be heard tomorrow, my lord.
What is it about?
In this matter, my lord, it's a writ appeal, my lord, and for the appellant. In this matter, the appellant has been ready to pay back the loan. However, the appellant already requested the honorable single judge to let the encumbrance certificate and the original document deeds be discharged in her favor. That part has not been culminated in the order, my lord. Hence, this matter may be kindly heard tomorrow. Since they might take position tomorrow, my lord. There's urgency in the matter.
7.
The matter has been listed for 8, my lord. But the matter has already been listed for 8, my lords.
It is already listed.
It's already listed on 8, my lords.
Then file IA.
Certainly, my lords.
File IA and we'll list it.
Certainly.
Mention again after filing IA.
Certainly.
Contempt matter, seal number 1, Sharun BM.
I appear for the complaint.
Preparing for the response.
The order is of 2021
Please, my lord.
and the contempt is filed in 2024.
23.
But that is explained because notification of issued subsequently.
Let us,
Kindly see the order, my lord.
let us see order. What is the order?
One is about the delay and the second aspect.
One second. What is the direction? Let us.
My lord, may I will get it at page 168, my lord.
168, yes. Notional seniority.
Then we deem it appropriate. To direct the respondents 1, 4 and 5.
Paragraph.
To consider the case of the petitioners for benefit of notional seniority
given to BL Narayan pursuant to orders passed by the Honorable Apex Court in WP number so and so, on so and so, without any monetary benefits and other consequential benefits. After providing an opportunity of hearing to all the affected parties, such decision shall be taken by the respondents 1, 4, and 5 in an expedient manner in any event within a period of 6 months from the date of receipt of the certified copy of the order. That decision was taken, I have explained in para 16, my lords. They took the decision, para 16 at page 13, my lords. Page 13, running page 13 of the contempt petition, para 16. That the order in question was passed on 15/1/2021, directing respondents 1, 4, and 5 therein to take a decision within a period of 6 months from date of receipt of the certified copy of the order. The complainants have notified the accused on 2/2/2021. The accused number 2 has issued a notification dated 4/3/2022 with the consent of the accused number 1, and thereafter issued an endorsement dated 28/6/2022 and not complied with the directions of this honorable court. The contempt filed on this day is within 1 year from that date. The order is complied on 28/6/2022, endorsement. Within 1 year it is filed.
My lord, last time I had made a mention as to the delay. Now the order, that is the endorsement which the learned counsel is referring to, is the endorsement of rejection pursuant to the order of the learned division bench. And therefore the appropriate remedy would be to challenge that endorsement. Because the division bench, my lord, at page 168, the direction is only to
Permit me to
consider.
argue the matter. Why, I don't know, he's so anxious to make submissions. But let her permit me to make arguments. The order was complied only on 4/3/2022. Annexure S, page 282, while issuing notification. Well within time, my lords. They did not pass orders within 6 months because of COVID. They did not pass orders within 6 months. On 4/3/2022, they issued notification at page 282, Annexure S. First time. It is within time from that date also.
That an endorsement is at page 280 to
287.
T7 is the English translated version, my lord. Annexure T.
That is within 1 year from that date. That endorsement is issued to us after this 4/3/2022 notification. 4/3/2022, your lordship will get it at page 237. First, they issued notification removing our names. Initially, they included our names. They passed a considered order in the proceedings at Annexure N, page 170. After this court directed, your lordship may kindly see page 172 typed copy. The complaints, proceedings. Page 175, it's in Kannada. Your lordship will get it at page 177. The same secretary to the government was the chairman of the committee, 177.
So as per the endorsement, you are denied the seniority.
Please, my lords.
As per the endorsement,
Yes.
you are denied the seniority.
Yes, my lords.
Then you challenge it.
No, not that endorsement. That endorsement is issued contrary to the directions of this honorable court. This honorable court has said notional seniority. Kindly see for what reason the endorsement is issued. Your lordship may kindly see 3 reasons they have assigned in the endorsement. All the 3 reasons are contrary to the directions of this honorable court. Lordship may kindly see page 287. One of the notifications they are relying upon, the recruitment was made. I'll just read the date of recruitment. At endorsement is at page 287, my lords, translated copy. If a new issue had arisen, I would have challenged that in a writ petition. The endorsement is contrary to the directions of this Honorable Court. Blatant violation of the Honorable orders of the Honorable Supreme Court. Last time I read the Honorable Supreme Court's order, which notes before I go to the endorsement, Your Lordship may permit me to read the order of this Honorable Court for a moment. May I?
My lord, if.
It is in contrary to the directions of this Honorable Court. Page 166 is the order of this Honorable Court. And I have also relied upon a judgment of the Supreme Court in contempt matters, how hair-splitting technicalities are raised to deny the relief. That is what I am contending, my lords. Kindly see the two paragraphs in the order of this Honorable Court at page 153. The order was something, endorsement is something else, extraneous to the matter, bringing in some notification subsequent to my recruitment. Page 153 is the order starts. Your Lordship may kindly permit me to read para 13 at page 166. Para 13 at page 166. The operative portion and reason for that order. May I read? Page 166, my lords. Para 13. Para 13, page 166. Order of this court. The Honorable Apex Court in WP number filed by B.L. Narayan has categorically observed that the learned counsel appearing for the state is not in a position to the same matter, my lords, to contradict the statement made by the petitioner that Karnataka Public Service Commission has appointed more than the required number of 351 by appointing less meritorious candidates, and the petitioners have secured more marks than selected candidates who have been selected under 30% reservation. 30% reservation is women, my lords. Instead of 283, they selected 351. It has also been recorded that declaration made on behalf of the state that the state is agreeable to verify the number given by the petitioner, and if he has secured excess marks of the last candidate selected in woman candidate, his case would be considered and appointment would be given. Considering these aspects, the said petition came to be disposed of with the direction to consider the claim of the petitioner therein. B.L. Narayan, having regard to the principle laid down by the Honorable Apex Court in civil appeal number so-and-so, directing the respondent to take a decision within a period of 2 months, observing that if a petitioner B.L. Narayan is found to be eligible, he would be given appointment, however, he would not be entitled for back pages. It is not in dispute that B.L. Narayan was appointed on 29/9/2009 and was placed at serial number 94A. As said, the focal point of the controversy lies in a narrow compass, that is to extend the benefits on parity with B.L. Narayan, realigning the serial numbers of selection which would inure to the benefit of the petitioners regarding the promotion and retirement benefits. Petitioners have made it very clear that they are not insisting for any monetary benefits, but their claim may be considered regarding the inter se seniority in terms of the benefit extended to B.L. Narayan since he was placed at serial number 94A of the selection list. These arguments of the petitioner herein has also some force. However, no such relief can be extended to the petitioners in the absence of the other parties who would be affected by such realignment of serial numbers in the selection list. Hence, we deem it appropriate to direct the respondents 1, 4, and 5 to consider the case of the petitioners for the benefit of notional seniority given to B.L. Narayan pursuant to the orders passed by the Honorable Apex Court in WP number so-and-so on 29/7/2009 by so-and-so, without any monetary fees and other consequential benefits. After providing an opportunity of hearing to all the affected parties, such decision shall be taken by respondents 1, 4, and 5 in an expedite manner in any event within a period of 6 months from the date of receipt of the certified copy of the order, so-and-so. My lords, pursuant thereto, my lords may kindly see one document, the consideration of this at page 175. By the meeting proceedings, English translation is at 177. Till then, they were right, my lords. They had considered it correctly in compliance with the orders of the Supreme Court and this Honorable Court. Page 177 is the translate copy. Only 2 paragraphs I'll read in this. It's a short proceedings. Meeting proceedings dated 2/12/2021 convened under the chairmanship of the Secretary to Government for revision of graduation list as per the directions in writ petition number so-and-so regarding inclusion of the names of the 12 additional candidates, that is the contempt petitioners before this court, appointed for the post of Group B High School headmasters, equivalent post to teachers in the year 1999 through Karnataka Public Service Commission. No, my lords, may permit me to read para 2. Karnataka Public Service Commission, by its notification number so-and-so dated 25/2/99, has published a final selection list of 936 candidates and 234 candidates of additional list candidates for the post of Group B headmasters and equivalent post. Accordingly, running orders were issued for selected headmasters as they are working accordingly. During the preparation of the said selection list of candidates, while considering 30% horizontal reservation in respect of women candidates, was interpreted wrongly and 451 women candidates were selected instead of 283 candidates, vertical reservation, and 67 women candidates were selected in excess to that of prescribed limit as per the reservation. Out of these candidates, 12 candidates have approached the High Court by filing a writ petition so-and-so. Next, accordingly, gradation list was revised based on the marks obtained as per the direction of the decision of the division bench of the Honorable High Court dated so-and-so. Joint Director Administration has brought before the meeting that the provision gradation list was already published. Now the below mentioned 12 officers should be included as per the revised provision list at the commissionerate level, and suitable time should be given as per provisions to the agreed parties to file their objections. Objections filed by the agreed, my lord, still here, they have considered the matter in the light of the directions of this court and noted that the excess women were selected in 30% reservation. Now kindly see the endorsement, which then they issued notification. I'll not read that at page 180, 18/1/2022, including us. They themselves included. This is issued by the commissioner. Translated copy is at page 282. Translated copy. Commissioner himself issues the notification pursuant to these proceedings. Now he contradicts in the endorsement. 282 is the translated copy of that notification.
You filed your compliance.
Please, my lord, we have filed our
Very-
compliance report.
Very.
My lord, if I may submit, if the learned counsel doesn't interject, I'll just give a brief synopsis of the history behind this case, my lord.
No,
My
Where is your compliance?
compliance, my lord, is
It is there.
dated 7/2/2024
It is 7 to 10.
and 29/8/23. Now, in the compliance report, my lord, dated 29/8/2023, we have filed the endorsement. The endorsement, which is also part of the contempt proceedings at annexure R3, that is 28/6/2022. Now, my submission is only twofold, my lord. One is, firstly, there is a delay beyond 1 year, which is in violation of Section 20 of the Contempt of Courts Act. And secondly, that the endorsement is issued, taking into consideration what the division bench had ordered, to consider the representation whether there is parity can be drawn to BL Narayan's case. That has been considered and the endorsement accordingly issued on 28/6/2022. Therefore, my lord, my submission is, in contempt proceedings, the merit of the matter cannot go into, and the endorsement has already been issued. And I would like to rely on 3 judgments, my lord, with regard to maintainability. One is, my lord, Lalit Mathur.
Where is your endorsement? Same at page 287.
Yes, it's the same.
Same.
It's the same. I would like to rely on 3 judgments, my lord, just and take this honorable court through the checkered history. My lord, let me
Only one
finish.
submission.
Started.
I'm
So
sorry,
let
I'm
me
sorry.
finish,
Only
and
one
then-
submission, my lords. After they filed the compliance affidavit, this honorable court took note of the matter and 30/10/2020 passed this order. Kindly see the order, my lords. Court said that compliance affidavit is not in consonance with the directions of this court and the Supreme Court. Kindly see the order dated 30/10/2023. This court heard the matter Said compliance affidavit is in contrary to the Supreme Court directions and the dishonorable court directions. 30th of October, my lord. There is already an order. The submission of the learned counsel for the complainants is that the respondent accused by way of an affidavit dated 29/8/2023 submit that is compliance of the order of the learned single judge placed on record a copy of the endorsement dated 28/6/2020 as annexed to the affidavit. The said endorsement runs contrary to the direction of the division bench and also to the view adopted by the Honorable Apex Court in Rajesh Kumar Daria versus so and so, more particularly in para 9 of the judgment.
For orders on 7.
My lord, I would like to just rely on 3 judgments, my lord. I'll place it before your lordship. One is Lalit Mathur.
And one more submission, that is contradiction in the additional affidavit. Para 8 says they are not bound by Rajesh Kumar Daria judgment, it is not applicable. Then they contradict in para 11 and say the Rajesh Kumar Daria they have complied with. It's same affidavit, my lords. How the officials take the courts for right? Para 8 and 11 contradicts.
My lord, if I may please submit for a bit. With this case, my lord, that is the Lalit Mathur case, we are looking at para 3 and 4. Here, this case was when the High Court order was to consider the representation and the same has been done and rejected on merits. Then it leads to a fresh cause of action, and the cause of action to be taken by the complainant is to challenge that order or the endorsement. 3 and 4, my lord, the above will show that the High Court has directed the state to absolve the respondent against the suitable post either in the government department or in the public sector undertaking. This order, in our opinion, is wholly without jurisdiction and could not have been made in proceedings under the Contempt of Courts Act under Article so-and-so. The High Court in the writ petition had issued a direction for consideration of the respondent's representation to the state government. This direction was carried out by the state government, which had considered and thereafter rejected the representation on merit. Instead of challenging the order in a fresh writ petition under 226, the respondent took recourse to contempt proceedings, which did not lie, as the order had already been complied with by the state, which had considered the representation and rejected it on merits. And therefore, it goes on to saying the contempt petition filed by the respondent is dismissed. However, it is left open for him to challenge the same as appropriately. Now, the second judgment I would like to rely on, my lord, is Parivar versus Ganpat, Dugar and others. This is para 6, my lord. The controversy over here related to seniority list of engineers in the Rajasthan Civil Service Engineering Services, like the KPSC in the instant case. Now, para 6, if I can take your lordship, which is the relevant portion, the question then is whether the division bench was right in setting aside the direction issued by the learned single judge to withdraw the seniority list. It is contended by Mr. So-and-so, the learned counsel appearing for the appellant, that unless the learned judge goes into the correctness of the decision taken by the government in preparation of the seniority list in the light of the law laid down by the 3 benches, the learned judge can come to the conclusion whether or not the respondent had willfully or deliberately disobeyed the orders of the court as defined under Section 2B of the Act. Therefore, the learned single judge of the High Court necessarily has to go into the merits of that question. We do not find that the contention is well-founded. It is seen that admittedly the respondent had prepared a seniority list on 2/7/1991. Subsequently, promotions were made. The question is whether seniority list is open to review in a contempt proceedings to find out whether it is in conformity with the directions issued by the earlier benches. It is seen that once there is an order passed by the government on the basis of the directions issued by the court, there arises a fresh cause of action to seek redressal in the appropriate forum. The preparation of seniority lists may be wrong or may be right or may not be in conformity with the directions, but that would be a fresh cause of action for the aggrieved party to avail of the opportunity of judicial review. but that cannot be considered to be a willful violation of the order. After exercising judicial review in contempt proceedings, a fresh direction by the learned single judge cannot be given to withdraw the seniority list. In other words, the learned judge was exercising jurisdiction to consider the matter on merits in contempt proceedings. It would not be permissible under Section 12 of the Act. Therefore, the division bench has exercised power under so and so. So basically, my lord, my submission here is under contempt proceedings, the endorsement has been issued as per the direction of the Honorable Division Bench. So in contempt proceedings, it cannot be rewound and gone into and looked into merits. Finally, my lord, my last case I would like to rely upon is Arumugam versus Balakrishnan. Over here, it speaks about contempt jurisdiction, that it should be within the four corners of the order. And my humble submission is the endorsement issued is within the four corners of the order of the division bench. Here, I would like to place reliance on para 18, my lord. Para 18 of this judgment. Para 18 of the judgment is what I would place reliance on, which pertains to in contempt jurisdiction. The court has to confine itself to the four corners of the order alleged to have been disobeyed. Observing that in the contempt jurisdiction, the court cannot travel beyond the four corners of the order, which is alleged to have been flouted. And the court's, my lord, if I may read, the extraction of para 19, the courts must not therefore travel beyond the four corners of the order, which is alleged to have been flouted, enter into questions that have not been dealt with or decided in the judgment, or the order violation of which is alleged. Only such directions which are explicit in a judgment or order or in a plainly self-evident ought to be taken into account for the purpose of consideration as to whether there has been any disobedience or willful violation of the same. Decided issues cannot be reopened, nor can a plea of equities be considered. The courts must also ensure that while considering the contempt plea, the power available to the court is in other corrective jurisdiction like review and appeal is not trenched upon. No order or direction supplemental to what has been already expressed should be issued by the court while exercising jurisdiction in the domain of contempt law. My lord, based on these three decisions, I would like to submit that we have, in compliance of the division bench, issued the endorsement, which is at Annexure T. And having said that, my lord, I would also like to draw your lordship's attention. This has a checkered history, this entire case. Basically, the complainants herein are claiming parity with an individual called B.L. Narayan. B.L. Narayan was not in the first notification, that is the provisional notification or the final notification, because there was some, and this was 10 years ago, my lord. We're not talking about today or tomorrow. These are fence sitters who did not approach the court at the relevant point of time. And now they filed contempt. Now, the complainants, my lord, I take your lordships to the manner in which the complainants have come before this court. They went to the KAT challenging the first refusal, which is at page 131, my lord, Annexure K, which is the KAT order, which looks into all these aspects, and a well-written order, my lord. If I may take your lordship through that order for a second. At page 131 is the order, and the operative portion, my lord, 139. This is the KAT order wherein they challenged the first refusal. And this order at internal page number 9, my lord, if I read the last few lines, that is from learned counsel. from the 11th line, learned counsel for the applicants further submit that the applicants herein are similarly placed as they are higher in merit compared to certain women candidates selected in excess. Hence, they deserve to be included in the select list and appointed. He submitted applicants came to know about the fact of women candidates being included in excess beyond what rules permitted only after the judgment of the Supreme Court in B.L. Narayan. Now, B.L. Narayan judgment came in 2010, my lord. 2010, B.L. Narayan challenged that first selection list of 99, and the order comes about in 2010. They do not do anything till then. Even in 2010, they do not challenge. However, all these aspects cannot be looked into in a contempt petition. And then the KAT also looks into as to how at para 4, my lord, page 141, page 140 and 141, this is the arguments put forth by the KPSC before the KAT, which has been extracted. The learned counsel for the second respondent, KPSC, submitted that the position of law as brought out by the learned counsel for the applicant, that horizontal reservation of 30% under Rule 9AA of the KCS General Recruitment Rules as interpreted so-and-so holds ground. He further contended based upon Shri B.L. Narayan was placed in the additional list and not in the main list and was not appointed. So what happened after the Supreme Court order? B.L. Narayan came to be added in the additional list. He was not part of the first list or the second list. He came to be added in the additional list and the last, so that the entire seniority or the list that is done in 1999 does not get revamped or the cycle is not disturbed. Appointed as a mention on behalf of applicants for KPSC, further submitted that applicants have approached the tribunal on so-and-so, whereas the selection list process had come to an end long back in 1999 on publication of the final select list. It submitted that he submitted that KPSC is a constitutional body to make appropriate recommendations, and once final selection list is submitted to the respondents, the question of redoing the list does not arise. It is submitted that in view of the inordinate delay and laches in seeking relief, even though it is a fact that women candidates were appointed in excess, the applicants do not have any right to seek appointment on the basis of judgment of the Supreme Court. So these are the contentions raised by the KPSC. And then finally, the KAT looks into all these aspects and gives the order at para 8, that is at page 144. Further, the Supreme Court decision in 3-bench in BSNL so-and-so, clear that the applicants had not made any grievance for almost 10 years, and only after relief was granted to B.L. Narayan, pursuant to specific Supreme Court decision in the matter, they have filed the representation, and thereafter present applicants to seek similar relief. We find merit in the submission made by the government and the KPSC that the prayer is made after inordinate delay and liable to be rejected on account of delay and laches involved. The judgments of so-and-so, Supra are also directly applicable in the context of the present case as well. The submission of the KPSC that final selection list is published in the year 1999, over 15 years back, is absolutely true. They're based thereupon, first and fifth respondent had gone ahead and already made appointments so-and-so. Considering all aspects, we are of the view that these are not a fit case for interference. So this was the judgment of the KAT, and now we are in contempt, wherein the endorsement has been issued. Therefore, the appropriate remedy for the complainants herein is to challenge the endorsement in accordance with law.
So for orders on 8th of this.
Grateful.
Simply to be.
Much obliged, ma'am.
This is number 2, Mr.
Here
Rajeshwar
for the
PN.
petitioner, my lords. The learned single judge has directed the respondent accused, my lords, not to enter the property and not to lay the electricity and water lines. In violation of the said order, my lords, the respondents have entered. Learned single judge, my lords, as per order at page 21, directed the private parties, my lords, respondents, not to enter the suitable property and
Interim order.
that now has been confirmed, my lords. Matters disposed of on 22nd October, confirming this order, my lords. I have not yet received the order copy.
Where is that order?
Because that order is not yet released, my lords. 22nd October, the order was made, my lords.
Not
This
annexed.
order was confirmed,
Where is that confirming?
not yet released, my lords, not yet released.
Bring that.
Please.
Number 3, Akshay Kumar Jain.
Order has been complied with,
Order has
filing a
been
memo for
complied.
withdrawal.
Look at Mr. So. Rajeshwara PN,
No, third one.
No, serial number 3, Malad.
3, my lord.
Akshay Kumar Jain
Please.
states that the order under contempt is complied with. On an additional government, so and so, so and so. Harish.
Please.
Harish.
Yes, sir.
Comes the statement of compliance, statement about compliance. In view of above, nothing survives in the proceedings. They are disposed of, not survive.
Seal number 4, to GS Venkat Subrao.
Time for the accused in this case, Manoj. Now, what transpires, Manoj?
It's 384.
I have to file affidavit reply. Let's pursuant to the order of the learned single judge. Amendments were made, Manoj, to the act. And Manoj, these demands were also a part of the renewal, Manoj, as retrospective effect was also given. Manoj, that is also challenged, Manoj, subsequently. That, Manoj, is pending, please, Manoj, for orders. It's heard and reserved. The judgment is reserved in this case. Because amendment was brought inside. This was before the amendment. This
Here,
judgment of
here
the-
what is the direction?
384, my lord,
384.
384. Last but 2 paragraphs. That matter was, my lord, pertaining to, my lord, payment of, my lord, fee for occupancy certificate which was under challenge. This honorable court directed, my
Oh,
lord,
they are saying that amendment is made.
amendment is made, and after the amendment, please, Milord, subsequently, they have a further challenge to the amended act and virus of the amendment and Milord, the demand made pursuant thereunto.
It
The
is also-
amendment took note of this judgment and Milord, also the demand made earlier.
What happened to subsequent proceedings?
That
Challenging.
Milord is pending, Milord, it is heard and reserved for judgment. Milord, the orders will have to be
No,
passed.
then wait, 3rd December. Nothing survives as such.
Lord, my lord, I'll examine, my lord, with regard to, and nevertheless, my lord, there is no stay of
That
the,
is enough. We need not wait about the outcome. There is no contempt.
but nevertheless, my lord, it should ought to have been considered at the relevant
please,
point of time.
3rd of December, you consider.
Milord, I will, please, Milord, it is already heard and it is posted for judgment. In the event, Milord, it is declared virus, please, ultra virus, please, Milord, of the constitution.
Even then, they will not, contempt will not survive. Why not disturb this positive?
My lord, let me check through, my lord, if my lord
Then
puts it in writing, my lord, I could, at least I could, my
File
lord,
an
make it.
affidavit.
put something on it.
I'll file it in writing.
20th,
That's 2 weeks, Milord, I'll file.
20th November.
20th. So will.
Pleasure.
To be listed at 2/3.
December 5, to Vijay Kumar.
And for the complainant in this.
Notice returnable on 3rd December.
matter.
Number 6,
Please return on 4th December.
seal number 7,
4th December.
Please, lord.
seal number 8,
The complainant, my lord.
Monica Patil.
My lord, the interim order is at page 16, my lord. I've produced the order sheet. A suit for defamation and injunction was filed before the trial court, and an interim order was passed restraining the accused from posting any defamatory content. Thereafter, my lord, the same was intimated to him through a compliance notice. However, he yet again continued to post such defamatory content. Hence, a contempt notice was issued, my lord. He issues a reply notice to the contempt notice, my lord, indicating that amounts are due to be recovered from the complainant. However, he continues to post till date, my lord, and we have produced, we have indicated all the links where he has continued to post such defamatory content. If I may just point out the order and his reply notice, my lord, because he indicates that he has due knowledge of the proceedings. At page 16, my lord, is the order sheet. The interim order is at page 18, my lord. The defendant or his
The
agent.
interim order, heard learned advocate Miss so and so, so and so. The order which is brought under the contempt jurisdiction, invoking provisions of Contempt of Courts Act 1971, is ordered it at 29/6/24, passed by learned City Civil and Sessions Court, Bengaluru, in the proceedings of OS number 3021 of 2024. Paragraph. The order is an interim order, which reads as under paragraph page 18. Also, the aforesaid order came to be extended from time to time. Also, the proceedings of the suit are pending and are pending. Paragraph. Since the order is interim in nature, so it doesn't crystallize finally
If I may,
rights of any of the parties. Not only that, the petitioners have remedy to approach the same court by
if I may just
the
point out, my
provisions
lord,
of
my
Order
apologies.
39, Rule 2 capital A of the Code of Civil Procedure 1908. It is open for the petition to avail such remedy in accordance with law. The aforesaid view, without going into the merits of the aspects of the controversy and the order under contempt.
My lord, the reason is, my lord, he
Petition
has
is not under
intentionally
contempt.
not appeared before the trial court, my lord.
Stand.
My lord, since he is not a resident of
Go
Bangalore,
before same court.
it's pending service of notice, my lord, and he is continuously violating the order. Hence, we had preferred the instant
Go
petition.
fast.
My lord, in fact, in his reply notice also, he has indicated he is aware of the proceedings, but he chooses not to file wakalat in the trial court proceedings, my
If you
lord.
go on in entertaining the interim orders in this contempt, there is still no end to it. We have remedy under 39(2)(a), breach of injunction.
Since.
Number 9.
someone so, please.
Mr. Bob
Please,
Rao.
my-
Yes, who appears? 9. Yes,
September 23, my lord, the learned single judge order. In July, they have given the representation, my lord. Next, B. Operative portion of the learned single judge, my lord, day number 13. Accordingly, the
heard
order.
learned advocate Mr. So and so for the petitioner, full stop. This contempt petition is directed against. This contempt petition is filed in respect of the directions contained in order dated 22nd September 2023 of learned single judge, full stop. The operative part reads as under paragraph, page 13, paragraph 3. Full stop. A bare reading of the aforesaid direction would go to show that for the purpose of processing the application of the petitioner and for effecting khata on the way of the bill dated 13/8/2009, any time limit is not prescribed by the by learned single judge. Paragraph. When the time limit is not provided for in the directions, it cannot be said that any of the respondents have at this stage committed contempt of the court, much less any willful contempt. Also, therefore, the invocation of contempt jurisdiction is not well conceived. Paragraph. At the same time, the directions of the court should not go uncomplied with. Therefore, while not entertaining the present contempt petition, it is provided and directed that the directions of learned single judge in the aforesaid as quoted above, shall be complied with within 8 weeks from today, failing which, the petitioner will be entitled to invoke the provisions of Contempt of Courts Act 1971 against the defaulting respondent. Disposed of accordingly.
Number 10.
Order, my lord, September, by September, within 1 September, my lord, I gave the representation. It is pending, it is not considered. Since time is not given, my lord, they have not stipulated, learned single jet time is not stipulated.
We have stipulated.
Now it is stipulated.
We have stipulated.
Stipulated.
Illa, helilla.
8 weeks and
We have stipulated the time of 10 weeks, 8 weeks.
8 weeks.
8 weeks.
December 10.
Obliged. Obliged.
Same, no time limit.
Please, Manoj.
Same order. Voting will be,
Manoj, 8 weeks would be,
quotation part will be this much.
I've retired a decade ago, Manoj. 8 weeks would be, Manoj,
8 weeks,
4 weeks, please, Manoj.
8 weeks.
8 weeks.
Manoj, the order is of 20th February rather. Manoj, I've retired, Manoj, in the year 2014.
Maybe
Manoj, a decade has passed.
to be able to type.
Number 11.
Great.
Keshav.
11 notice returnable on. Who is there? Nobody is there.
Keshav.
Keep that. 2/3.
Number 12. To Jagir Dar Vidya R.
Keep back.
Number 13. Vijay Kumar.
The order of the learned single judge is at page 20, my lords, is passed on 19th of April 2022. My lord, the cause of action arose only in violation of this order, my lords, at page number 115, annexure F, by which, my lord, the order of the learned single judge is violated. My lord, the state government, my lord, preferred a writ appeal, my lords, which is pending consideration before this honorable court, which is at 113. During the pendency of the writ appeal, my lords, we did not insist upon, for preferring the contempt proceedings, my lord. My lord, the matter is seized before this honorable court. My lords, as for annexure F, page 115, my lords, there is a violation of the order of the learned single judge. The relevant is at, my lord, page 58. Is the order portion of the learned single judge. Paragraph 3, 4, and 5, if my lords could see. Lord, there's a clear violation, Lord, though the writ appeal is preferred, the matter is pending before this honorable court. Lords, they.
Will issue notice. Notice
Please.
returnable on 4th December.
I'm grateful.
Number 14. To Prakash.
Lord, the order passed by
Notice
the
returnable on 5th December.
notice order. Great.
Number 15.
The petition.
To Vasant Kumar HT.
The impugned order passed by the learned single judge, page 20, page 29, my lord. Upper portion of the order, there is a direction to consider the representation of the petitioner.
Notice
within a period of
returnable
3
5th December.
To number 16.
The complaint,
Vikas.
my lord. Court order dated 14/6/2024, my lord. The complainant, my lord, is a research scholar, my lord. Earlier, my lords, one of the previous guide had unilaterally withdrawn from being my guide, but the university had not provided an alternate guide, my lord. Subsequently, after I filed a writ petition, my lord, they provided me an alternate guide, my lord. In the writ petition, the court passed an order saying, just like previously, I should be allowed to use all lab facilities and have access to lab, my lord. But after the passing of the order also, my lord, they're not giving me the keys, my lord, of the deep freezer and the almirah in which research materials are kept.
There is only declaration, no direction.
My lord, kindly see page number 44, my lord. There, 44.
44.
Writ petition order, my lord. Their
You are-
order, my lord, order B is,
You are arguing 1122?
yes, my lord.
There is no page 64.
My lord, much up.
Page 20 is there.
Page
Already.
20, yes, my lord. Page 20, my lords, it says the submission that petitioner's research work for a doctoral work shall continue with the university is taken on record, and consequently, the petitioner shall be entitled to access and use all lab facilities with the university as earlier, and her doctoral work shall be guided by the newly recognized guide. Now, for me to use lab facilities, my lord, they're not giving me the key, my lord.
And file a writ, seek a writ of mandamus.
My lords, there's already an order, my lord, saying you should allow them to use the facilities.
Where is
Here-
the order? Where is the direction to be compliant with?
My lord, here, my lord, there's no.
Only a declaration that
My
you
lord-
are entitled to do so.
Yes, my lord.
Then it doesn't amenable to contempt.
My lord, one submission, my lord.
This is something giving you a right. So you
No, no,
seek a mandamus.
My lord, I'm a
Contempt cannot be invoked.
my lord, I'm a research scholar.
Maybe you are very,
Obligation is on the university to give me facilities to do research work, my lord.
maybe a researcher,
not asking-
scholar, but not good enough to be a contempt petition.
My lord, sir, one submission, my lord. In this case, my lord, when order was passed, my lord, the university has not objected. University has said we will provide them all facilities. After the order was disposed, my lord, they're not giving me the keys, my lord. All other students have been given keys. I am the only one who has been singled out and keys not given, my lord. That's all I'm asking, my lord.
Notice written on 3rd December.
Number 17.
The complainant. The direction to be complied is at page 14, ma'am. Respondents are hereby directed to open the seal cover and give effect to the promotion of the petitioner to the post of veterinary microbiology. Then this time period was also fixed, my lord. Your lordship gets it at page 16. This direction was to be complied with on or before 23/6, page 16, my lord. Has not been.
Notice written
Please.
on 4th December.
Number 18.
Hearing for the
Naik.
my lord. The order of the learned single judge is at my lord page 14, or passed on my lord 22nd June. My lord, initially my lord, the BDA sanctioned the plan and it cancelled the same my lord for no delayed payment. We approach this honorable court, my lord, the learned single judge has directed the BDA to issue necessary sanction plans, my lord, within expeditiously as possible, and also issue, my lord, the details of the payments. But we have given the representation also. We are running an educational institution. Lord, operative portion is at page 17.
Notice
Please, great,
5th December.
great.
Number 19.
Pay for the complainant, my lord. My lord, and before my lords for the willful disobedience of the order dated 20th December 2023, my lord, at Annexure A, page 13, wherein the learned single judge had directed that I be reinstated in service with immediate effect. The operative portion is at page 27, my lord.
Immediately notice.
Please, my lord.
Notice 27th November. Reinstate them. This is only.
Thank you. PL matters, seal number 20.
My lord, for a
Savant BL.
petition, my lord.
Yes.
My lord, on the basis of the statement given by the chief minister in the assembly, on the statements given by the petition, the chief minister in the assembly, my lord, there is a paper publication, my lord. Kind of page number 70, my lord.
So many papers.
Page number 70, my lord.
Papers and papers. What is this?
Page number 17, 70.
17.
May I read, my lord? 70, 70.
70.
Yes. The last column,
1 second. Where is say 70?
770. The Times New Network. Annexure 212, Z12. Annexure Z12,
Page 70.
70.
Newspaper article.
Last column.
The court finds that this petition styled is public interest petition is based on
All newspaper.
articles
Yes.
which are annexed. However, the petition is wanting in pleadings, full stop. It could have been dismissed on that ground. Pleadings, full stop. It is open for the petitioner to supplement his case with appropriate specific pleadings to the satisfaction of the court. How much time will need?
Oh, 1 week, my lord.
2 weeks?
2 weeks.
2 weeks. Learned advocate at this stage prays for time. For 2 weeks, stand over to 28th of November,
Yes,
29th of November.
yes. Number 21, Sachin.
No, serial number 21, your lordship.
Serial number 21.
The public interest litigation, your lordship.
Yes, what is it? 21.
Your lordship, in this case, your petitioner is residing at Mutgi village, your lordship.
Some construction.
And your lordship, the annexure A, your lordship, the reflected the your lordship, the government is allotted the land to the government bus stop, bus stand, your lordship. Which is at annexure A, your lordship, page number 37, your lordship. Is it reflected?
So
your
government
lordship,
has allotted land to illegal construction in the
allotted
bus
to
stand.
for Mutgi village bus stand, your lordship.
So what kind of construction is going on?
Now, your lordship, the unknown person has demolished that bus stand, your lordship.
What is the
And,
construction going on? What is the nature of construction?
The nature of construction, your lordship, there is a one bus stand, your lordship, that bus stand is demolished
Why don't you
by
come?
the someone.
You are not in Bangalore?
No, I mean Dharwad, your lordship.
Dharwad, all right.
If the
This is going on
at
where?
in annexure B, your lordship, the
Baswana,
government, the
Bagewadi
PDO has
district, Vijayapura, district Vijayapura. So you tell us the nature of construction in the bus stand according to you, which is going on. Facts in brief.
Now, your lordship, illegally, the one circle is constructed by the someone, your lordship. And the Mutgi village people has given the representation before the various authorities. Response has not taken any action, your lordship.
So Panchayat has taken possession of the property.
Pardon, your lordship.
We issue notice. Notice returnable on 25th November.
Meanwhile, by interim stay, your lordship, the further construction, maybe
Nothing
stay, your
going
lordship.
on. On the contrary, it appears that the Panchayat has taken some remedial steps.
And your lordship, kindly direct the at least the Panchayat respondents, to your lordship, to make the
We are issuing
make
notice. Will
take the strict action against those people, your lordship, and protect that land, your lordship.
Either will take action against you or against the respondent. Right? 25th.
Till number 22, says Sumoto PAN.
The mic is. This is
I appeal for the petitioner.
matter we have produced, we have prepared a status report, seeing the state government's affidavits. Primarily, my lords, I think efforts are on. The reduce, we have got the statistics also, my lords, by the health department. It's come down to about 300 per week, 350 per week all over the state. My lords, we have only given our observations and recommendations that the efforts can be on, so that that's the only.
My lord, I have filed an affidavit.
I've seen
My
that.
lord's notice,
Based
my
on
lord,
that.
the enhancement
Where
of
is-
the
where
penalty
is-
amount.
Where is your last affidavit?
My lord,
29.
29/10/2024.
Page 29, 24, all right. So based on your affidavit and the response,
Yes, we've gone through discussion. Your
close
Lordship.
the proceeding.
Yes,
We'll-
we have only given some
But,
recommendations that the efforts may be kept on so that
That will-
that's the only thing.
My lord, sir, for the
Lord, I-
BJP filing an updated memo, my lord.
Yes,
My Lord, I appear for the petitioner, my Lord. I have not received a copy of the affidavit filed by the government. My Lord, there are two things, my Lord, that were pointed out. One is, my Lord, that they have now come out with a notification forming
You appear
regulations.
for-
I
you
appear
appear
for the
for-
petitioner, my Lord, the registrar.
Only the
Madam, supply
amicus, I was
copy
as
then.
a amicus, I was appointed, so I filed.
Anyway, supply copy.
Yes, we have given it to the state. The state has to give it.
What is
And for BBMP, my lord, I'm filing an updated memo with all the reduction in cases and also the fines which are collected, my lord. It has been reduced by 90%, my lord.
But then since copy is not
I will
given,
do that,
give copy to
my lord. I'll
council,
serve
we'll
it in
keep,
court.
we'll keep this on, 10th. 10th is Sunday,
This Saturday.
11th,
Please,
and dispose it on that.
please.
Grateful.
But in the meantime, you give.
Yes, ma'am.
Wait.
Number 23,
I pay for the first question.
Mr. Shreyas S. Kumar.
That this matter pertains to my lord, the petitioners. From the sir. I pay for the petitioners, my lord. Landslide, my lord, out of, my lord, 7 dead bodies, my lord, 6 were found. My lord, weeks back, my lord, the lorry which was missing in the river and the driver is also found, my lord. Therefore, my lord, that I'll place it on record, my lord. The state is also have to file it on the record, my lord.
I'll do that, ma'am.
Please, both of us, my lord, weeks time, my lord.
Lord, 2 weeks, my lord, I'll, with the details.
What is, leave it to my lord.
Or learned advocate, so and so for the petitioner. For my learned additional
Deputy Solicitor, Shanti Bhushan,
Solicitor General, Mr. Shanti Bhushan, for respondent number 1,
please.
Union of India, assisted by learned advocate, so and so, and learned additional government advocate, Srimati Neelo Parakar, for respondent 2, State of Karnataka. This petition was filed, public interest petition. Post petitioner happened to be a practicing advocate, the High Court of Karnataka. The first petitioner happened to be the practicing advocate of the High Court of Karnataka, and second petitioner is practicing advocate in the Supreme Court. The petition came to trial in wake of A massive landslide occurred at Shirur village in Kola, Uttara Kannada district, Karnataka, on July 16, 2024. The mishap took place at National Highway 66 in the Uttara Kannada district, following a heavy rainfall. Full stop. It was stated that the soil formations fell over the roadside tea shop into the Angavali River and it occurred within the jurisdiction of Ankola police station. Pereira. It was stated that Shirur is located between Mangaluru and Goa on National Highway number 66, and the stretch of this stretch at the National Highway is flanked FLNKD by a steep hill on one side and Gangavali River on the other. Full stop. It was stated that due to landslide, at least one Bharat Benz truck carrying registration number KA 15A7427 and some other 3 cars went missing. The casualties were reported, which were as many as 7 in number.
Please.
Full stop. The public interest petitioners had a grievance about the rescue operations. What was prayed in the petition was to direct respondents to take all possible steps by clearing the entire debris round the clock to take care of the stranded human life and vehicles. It was also directed that the Union of India should depute Indian Armed Forces for the rescue operations. In response to the notice, the respondents appeared through their respective counsels and filed their affidavit detailing the rescue operations which are immediately carried out upon happening of the mishap. So this court dealt with the matter from time to time, and the orders were passed directing the authorities to take immediate steps to ensure that the life and property is not further damaged and the rescue operations are carried on with due swiftness. In order dated paragraph 24/7/24. The court took note of report filed by learned additional solicitor general regarding the measures taken by the authorities in relation to the situation obtained post landslide. Full stop. On 5/8/24, the further order was passed. In which the efforts and measures undertaken by the authorities were further delineated. It was stated that notwithstanding the impediments created because of heavy rains and floods, the rescue operations were carried on in full swing and the attempts were made to search out the missing persons. Paragraph. The authorities deployed the in addition to the rescue agencies, the teams of National Disaster Response Force into bracket NDRF and the State Disaster Response Force into bracket CRF, as well as the Army and Indian Navy teams to speed up the rescue operations. In all, 11 persons were found missing since the date of landslide and 8 bodies were recovered. It was so noted on the base of the affidavit of the respondents, in order dated 5/8/20. It was so noted in order dated 5/8/24 on the base of the affidavit filed by the respondents. Today, when the petition comes up for consideration, it was stated by learned Additional Solicitor General that even the remainder one body,
The only one body which was remaining.
which was missing and was not recovered so far, has been now recovered. Full stop. It was submitted that the is now back to normal and the traffic is restored. Vehicular traffic is restored.
Let the body, I'm sorry, body along with the lorry.
Body along with the lorry.
Lorry was also missing. It was immersed.
Truck. Body along with the lorry have been recovered. The situation is back to normal and the vehicular traffic is restored at the place, at the place. Paragraph. Learned advocate for the petitioner fairly submitted that rescue operations were carried out and all the bodies are now recovered. Full stop. About resumption of traffic, learned advocate the petitioner could not dispute the statement. Full stop. No, in above view,
The only body which was missing
present public interest petition is not required to be continued anymore. And the proceedings are closed.
Please.
Anything more?
No, my lord, my instructions are that, my lord, I'm sorry, my lord, the 3 bodies were missing. Out of 1, my lord, the petitioner pertains to this body, my lord. Insofar as other 2 bodies are, my lord, that is called off, my lord. The bodies are not found. The operations are called off. The operations are called off, my lord.
So 2 are not found.
2 are not found, my lord.
2 bodies are not found.
My lord, out of 11, they couldn't trace 2. So for that, my lord, the operations have been called off.
Also, it is stated that 2 bodies could not be found despite strenuous effort.
Please, all
The
technical.
operations are discontinued in that regard.
Called off.
Full stop. The court finds that there is a reasonable, that all efforts were made reasonably and no further action is required.
Lord, my instructions are that, my lord, for those 2 bodies which was missing, the state has announced 5 lakhs as compensation to.
From the Chief
from the
Minister's
Chief
Fund, my lord.
Minister.
This stage, learned additional government advocate stated that in respect of 2 bodies which could not be recovered from the state government has announced.
Lord, my lord can take it as payment of 5 lakhs is being processed,
Ex gratia compensation of 5 lakhs each.
is
to
being
family of the-
processed.
Family of the dead,
Yes,
and the same is processed.
is being processed.
It is being processed. It is directed that the compensations will be paid within 2 months.
Very well.
Great.
2 months will be paid. By
Yes,
completing
life-
all the formalities. Then I'll rearrange. Great. So out of 11, nine bodies were recovered.
My lord, out of 11, 9, 2 were missing, and my lord, for those persons, 5 lakhs each
Sure.
to the next of their kin.
Great.
Obliged.
Green bench matters, seal number 24. Shivraj and Naradi.
That environmental compensation orders demanded, my lords, were sought to be quashed in these writ petitions, my lords. And my lords have observed that there is no ground to proceed on that score in a review petition.
That's,
That group matter?
yeah.
Please, my lords.
Group matter, the
RP.
What had happened is, my lords, these petitions which are between 24 to 28, my lords, came to be disposed of. The petitioner council came ahead and filed a review petition, and the review petition came to be allowed. Now, my lords, the review petition on being allowed would be covered by my lord's judgment, where my lords, the demand notices have to be treated as show cause notice, and then all contentions of the petitioner should be left open.
My lords, my submission is this. The very jurisdiction to issue such notices have
That's
been.
not the question in this writ petition. My lords, may look at the prayer, and my lords, the same council. in
Will
that
follow which order? Any order, any of the order?
May I,
So it's,
may I
it's, my lords may see the order which
my
was passed.
brother,
Why this to be?
I'll take it. Page 36 of writ petition may kindly be sent. These all matters have been finalized, my lords, in 2020 itself. Your lordships also noted those aspects in RP and very clearly held that there is no such jurisdiction. There are no statutory powers to proceed like this. They are just trying to, page 36, my lords, annexure C, your lordships. At relevant page of the order is, my lords. At page 49, my lords, type to page number 14. My lords, am I there, your lordship? Lordships, the copies of the said orders along with memo placed on record in WP, although those said orders, we find no such direction has been given by National Green Tribunal to KSPCB or State Pollution Control Board to recover the demand environmental compensation, whether interim or otherwise, or environmental compensation charges. When we are called upon the learned counsel appearing for KSPCB to point out any such direction issued by the National Green Tribunal or specific provision under the provisions of Water Act, Air Act, or and Environmental Protection Act, which authorizes the State Pollution Control Board to claim such demand amount. The learned counsel is unable to show any provision or direction of the Honorable Tribunal to justify the demand of environmental compensation or environmental charges. In any case, impugned notices which are referred to do not state any statutory powers which has been exercised by KSPCB for making demands. Therefore, the demands cannot be sustained. Moreover, no opportunity has been given. My lords, my submission is this, my lords. When the provision itself, no provision, statutory powers are there to issue such demands.
Then we refer to this order in the.
Yes, my lords, that's precisely what I'm trying to make a submission.
If they want, my submission. I would like to submit.
Part of the entire argument, this kind of argument, is only raised the court time. May see the order which I have passed before my lords. In that, my lords, the same petitioner council with a connected matter with the same prayer, my lords may turn to.
All said and done, we are bound to follow our order.
Yes, my lords.
Lords, this order has been observed by your lordships in RP. RP also, which copies I submitted just now, my lords, in the very same petition, whereby my lords took notice.
So according to which order to be followed?
My lords, may.
This very same order was followed and therefore, my lords.
Now in this.
In WP number 5389 of 2020, the connected matters, my lords may turn to. Just one second.
No, which WP, sir?
WP number 5389 of 2020.
No, I'm not a
connected
party in
matters. Of course, he's a party to it. My lords may turn to page number 3,
2020.
WP. So 1 second, sir.
Yavudu, sir? Yavudu heli neevu number helidre. I should also have a reference. Right? You are arguing in
Being
air.
a party to it, my lords. My lords may turn to page number 3 of that order. It is WP number 19984 of 2023. The council name is the same council as before this court.
Yes.
The prayer which he sought for is the exact same replica as what he's showing in this particular writ petitions.
Page number?
My lords, in the judgment which I've just placed on record, page number 3, my lords, at the bottom quadrant in WP number.
19998.
My lords may turn to the next page. The name of the advocate, my lords, same advocate standing before.
Yes, my lord, I am R09.
My lords, that same page.
Let him complete. Yes.
Please.
the same page, the bottom quadrant, the relief which is sought for is also mentioned. And my lords have considered it. It was a lengthy argument, after which my lords,
What is
all the parties had agreed to
same direction will follow?
these.
Lords, may I submit?
Oh.
In this batch, my lords, my senior counsel was also there, whereby their petitions prayers were on the ground of seeking a demand notice, a show cause notice. My lords, my submission is this. My lords. That our own case, my lords, I conceded, my lords, there to treat it as a show cause notice. Now, what has happened, my lords? Those our own case notices were on so many reference points, my lords. So in this Govardhan's case, the petition, lordships, they are very minuscule, small scale industries.
So.
They are. And my lords, they have been trashed with such demand notice, which are per se non-sustainable as held by your lordships in 2020. That order was also observed by your lordships in review petition. Now, therefore, my lords, if at all state body has got any powers to exercise, let them issue any show cause notice further. And treating this as very show cause notice, my lords, will again keep the question open as to legality, whether such statutory powers were there or not.
Then all the contentions, 6.1.
Yes, my lords. Statutory powers already observed by your lordships in 2020 that there is no statutory powers vested with
So you
board.
can rely on that.
That they can, that's exactly was the contention.
It's already relied, and that RP judgment is also RP judgment, my lords, your lordships have observed in paragraph. I take your lordship's condition. RP judgment.
Heard learned advocate, Mr. Yuvarajan, Neighbor, Raj and Arali for the petitioner. And learned advocate, Mr. Mohesh Chaudhary for respondent.
Lords.
Karnataka State Pollution Control Board.
May
Yes.
one permission. This RP judgment, what your lordships delivered at page 5, para 5, my lordships. Because same copy, sir. RP judgment I'll from it. In fourth paragraph, my lords, at 4.4, my lords, it was observed that order was against the provisions of so and so provisions of NGT Act, my lords. And in para 5, your lordships observed. Am I taking you, lords? Para 5, lords. Having given attentive and anxious consideration to the aforementioned grounds, aspect raised by the review petitioner, recalling review order so and so, it could be noticed that NGT in its order dated so and so, in original number so and so, had not given any positive specific direction regarding imposition of environment compensation. And my lords, that is the very same basis, my lords, based on which these notices have been issued. And secondly, that, my lords, as observed by your lordships in para, my lords, this polymer judgment case, my lords, that is in writ petition, para 5.4, my lords. Para 5.4, this said decision, more noticeably, order brought to the review under so and so is misconceived by relying on decision or treatment to writ petition number so and so. That said decision is applied given in the present case. 33A was not a notice that was ordered, is what is observed by your lordships. And relying on and para page 5, my lords. The very same judgment, what we have annexed along with the writ petition, that is Polymer's case, Paragon's case. The decision in order dated 16/3/2020, writ petition number so and so, cognate petitions in Paragon Polymers Limited, decided on 16/3/2020, ought to have been followed, wherein the similar demand notice or intimate was set aside only on the ground that same was not justified by statutory provisions. Statutory, without there being a statutory powers, my lords, if they go on issuing such notices, my lords, your lordships have observed in this review petition also, and also in Polymer's case, Paragon's Polymer's case, whereby, my lords, very categorically there was a finding, my lords, and board wants to go on issuing such notices which are unsustainable, are not supported by provision of law, as observed by this honorable court. Now they want to rely on another judgment whereby they wanted to treat it as a show cause notice. In that case, my lords, how the decision of that case will not override the legal grounds that have been observed by this honorable court in earlier review petition as well as writ petition is what is my submission, my lords.
Otherwise, my lord, this keeps happening repeatedly. If they have powers, my lords, they have ample opportunity to issue any number of notices. We are governed by Water Act. We are under the superintendence of KSPCB, Pollution Board, my lords. They are not precluded by the orders of this honorable court in this writ petition that they are going to be stopping issuing any notices if at all I have contravened any provision, my lords. But let them exercise statutory powers is what is my submission.
What did you write? This petition is filed under Article 226 of the Constitution with a prayer to quash demand notice dated, demand notice dated 12/7/2023, passed by respondent 2. The environmental officer of Karnataka State Pollution Control Board, whereby the petitioner is imposed with and asked to pay within 15 days from the interim environment compensations to the tune of rupees 2,67,15,000. It is further prayed to direct the respondents, that's the State Pollution Control Board and its authority, to consider the reply dated 3/8/23 filed by the petitioner in response to the aforementioned demand notice. Going through the subject matter grievance. I'm going through the subject matter challenge and the grievance of the petitioner. From the record of the petition with the help of learned advocate for the petitioner as well as learned advocate himself, with the learned of the parties, from the court would immediately notice that the same controversy was addressed by the coordinate bench. Of this court in writ petition number 5389 of 2020 and cognate petitions decided on 4th July 2024. The directions paragraph issued in the state order shall govern the present case since the controversy is identical. Paragraph. In course of the hearing, learned advocate for the petitioner made a strenuous effort, content that the respondent, Karnataka Pollution Control Board, has been passing the orders despite the earlier directions issued by the court. He relied on the decision of the division bench of this court in Messrs. Peragaon Polymers Products versus Karnataka State Pollution Control Board, which was writ petition number 5847 of 2020 and allied petition decided on 16th March 2020. Full stop. From the decision, from the aforementioned decision in writ petition number 5389 of 2020 and allied petitions decided on 4th July 2024. So it could be seen that the decision in Messrs. Paragon Polymers Products Supra has been relied on and considered before issuing the directions. In the aforesaid view, from the present petition has to follow the same course as was in Messrs. Sanchez Engineering Limited Supra. So when you write this number, it's a parallel if the Messrs. Sanchez Engineering Limited, then Supra. Following directions are issued. And same direction. Same direction. One, two, three, four, five. Everything is same. Petitioners की जगह petitioner singular. And all petition लीजिए this petition.
Twenty-five, 26, 27, 28.
Same,
Until 28, same.
all same. Same separate order. Amount of compensation will be different. Prayer में देख लें.
Number 29.
Much obliged.
DC. 29.
We have followed petition.
Same.
My lords, the demand notice issued, my lords, by respondent number 2 is at annexure A and annexure B. That is at page, my lords, page number 16 and page number 18.
Same.
There's one thing, I think show cause notice has been issued.
Show cause notice was issued, my lords. We had replied for the same. And also, my lords, in this, my lords, make.
Yeah, show cause notice already issued.
Yes.
Thereafter this order.
That's why I turn to annexure A. Not to have the petition copy with me. Annexure A, my lords, in the reference is the last.
Yeah. 29/9/2020.
My lords, after annexure A, my lords, in annexure B, they send a revised notice, my lords. Again, for demand notice, a revised notice is issued. In this, my lords, what has happened is, my lords, a revocation was issued by the respondent number 2, my lords. In the beginning, a closure order was issued. For the same, we had complied, all the compliances were done, my lords. Later, a revocation and they had given a permission to. Please.
That's to have it day after. Matters covered by minutes, I would be the
Right.
day after.
8.
My lords, until then, my lords, the implementation of this.
They will not.
My lord, it is issued in 2023,
Please.
nearly a year old.
Notice have to be issued and it's copyrighted.
Notice written alone in 12th of,
I'm the only party then.
you are the only party.
Please.
My lord,
please.
I am also there, my lord.
State is
Notice
there.
written alone 8. Learned additional advocate, government advocate, Ms. Neelopar Akbar. Access notice correspondent state, whereas learned advocate, Mr. Chaudhary, accepts notice on behalf of Karnataka pollution, state pollution.
I'll have it clarified. Covered by that.
But to be listed at 2/3. Covered by which?
My lord's judgment.
Then.
I'll just clarify, my lord's, if show cause
Kind of.
notice has been issued.
Show cause notice has been issued as per, my lord,
Some revised demand notice has been issued.
Some minor changes will be
Please,
necessary.
my lords, it is not a similar matter, my lords. This needs to be heard. Much of.
Then in fact, nothing, sir.
Just check.
My lords, let there be notice issued, my lords. We'll order.
This is number 30. So Manjunath.
should take it a little earlier.
My lord, identical matters, my lord, I have been already disposed of. Same. Identical matters have been disposed of, my lord, already. Appearing.
Just.
Yes, my lord.
Similar.
writ appeal matters 31 urgent, seal number 32, Mr. Somshekhar. 32.
My lord, appeal for the appellant, my lord.
Yes.
This is a case divergent views. The tribunal Mysore held that the VRS was voluntary, where the learned single judge doubts that it is voluntary. He has taken 9 lakhs rupees and he has also become an advocate. Now practicing as an advocate, he did not return that money. I just refer, my lord, page 207 may kindly be seen, ma'am. Page 207 R2, my lord. R2, my lord. Second para. Last date for receipt of the duly filled prescribed application is 15/3/2012. The learned judge doubts this document also. Then, my lord, the application is at page 208. The VRS application, which was on 27/2/2012. Then page 210, my lord, R4. We informed him that it is accepted and he has been relieved from the services of the company. Then, my lord, he sends a letter, R5, which is in Kannada. The translation is at page 214, my lord. Page 214, my lord. This was received, this is a nil, dated letter nil, but we received it on 3/3/2012. I was serving in OTR department after 3 transfer of the OTR machinery plant. You have published reverse scheme. Accordingly, I have obtained voluntary retirement in view of my personal reasons. I am not in a position to come to the factory. Hence, I request you to send the money in the name of my wife, Parvati. And there is no pressure from anyone in this connection. Voluntarily, this letter is submitted to you. Therefore, we remitted the amount. But on 5/3, he sends a letter to us, my lord, saying that he is withdrawing it because his wife attempted suicide. Then page 73, my lord, in his cross-examination, 85, 86, my lord, in cross-examination, he admits. Page 85, my lord, in cross-examining, he admits that the learned single judge doubts you all these documents. Page 85, my lord, para 10. Shall I read page 85, my lord?
Hard learned senior advocate Mr. So and so for the appellant. This appeal is directed against judgment and order of learned single judge dated 19th February 2024, whereby the writ petition came to be allowed. And the appellant was directed to full stop. The judgment and award of the labor court was set aside, which accepted the voluntary retirement application of the respondent workman. full stop. Learned single judge set aside the judgment and award and directed the appellant management to reinstate the petitioner with full back wages and all consequential benefits. Full stop. The paragraph. Learned single judge proceeded mainly on the footing that the workman had that the application of the workman was accepted by the management on the same day on which it was given. Therefore, it was not a voluntary act on part of the workman, and that the application was taken from him by force. However, figures on record, the communication dated 30th/3/2012, whereby the workman requested the management that he had obtained voluntary retirement and that all the monetary benefits and financial and monetary benefits accruing upon the voluntary retirement should be sent in the name of his wife. It was stated that there was no pressure from anyone in this connection, and that the voluntary retirement letter was already submitted. Full stop. In the aforesaid view, prima facie, judgment and order of law on a single judge needs to be examined in detail. Paragraph appeal is admitted. Impugned judgment and order shall remain state. The appeal may be posted for final hearing after 6 months. Notice, your appeal.
Notice is not ordered.
Filed by respondent number 2 before your lordship. Number 637 of 2023.
387.
637 of 23, my lord. Respondent number 2 has preferred
My lord, respondent number 2 in this writ petition number also prepared appeal, my lord. Moreover, my lord, I have filed the contempt petition for compliance of the
So that
single judge order.
Other appeal is going to be listed when?
It is scheduled for 15th November 2024.
So it is stated that the cross appeal is filed
630 of 23.
by one of the respondents. Also, this appeal shall be listed along with the said appeal number
630 of 2023.
630 of 2024.
23, my lord.
In both writ appeal, my lord, there is no stay, my lord. The learned single is clearly directed to
First say notice in this notice returnable on 15th November.
Very well.
Then same order. Yes. Next.
I'm accepting the notice on behalf of the respondent number 1, my lord. Kindly
Learned
directed to-
advocate so and so accepts notice ke baad. Notice.
kindly directed to furnish the
accepts on behalf
writ
of-
appeal copy. my lord.
Then next, 33.1, 35, 34, yes.
Number 34. Mr. Prabhu Gowda Tungigi.
The appellant is a successful bidder, my lord, for
What is it
supply.
about? What is wrong in this?
Yes, my lord. He is a successful bidder, my lord, for supply of dry fodder, my lord, for any month. What has happened, my lord, because there is some calamity and all that, my lord, then permission was obtained to supply green fodders also. That has been permitted and we have supplied. In fact, my lord, out of that, 50% of the payment has been made by the state. The other 50% they have not paid. I filed an application, my lord, for the payment of money. Even the first payment itself was delayed by 14 months. The second payment is, my lord, about 33,44,262 rupees is due. They have supplied in a similar way, my lord, Bagalkot and Chikbalapura, 2 places I have to supply. Bagalkot, my lord, green fodder I have supplied, they have paid the money. But whereas, my lord, in Chikbalapur, they are denying the payment.
They have consumed and taken the whole lot. They've admitted for having supplied and they've received it and taken it. Two 2019 Maladan matter is pending. I don't understand. The state government is taking their own sweet time.
Sorry, heard learned advocate Mr. Swansea for the appellant and learned
Yes, Harish.
government advocate Mr. Harish, who appears upon service of copy of the appeal in advance. This appeal is directed against this appeal filed by the original petitioner is directed against judgment and order dated 10th July 2024. Whereby learned single judge dismissed the writ petition, leaving it open for the petitioner to approach the civil court for redressal of its grievance on redressal of its grievance. Paragraph. Order stated 11/1/22 paragraph and 16/4/22 passed by respond number 2, that's the Deputy Commissioner Chikkaballapur, came to be called in question by the petitioner of filing the writ petition. Thereby, the said respondent conveyed to the respondent that he was paid rupees 36,54,472. And that no further amount was required to be paid to the petitioner towards supply of the powder. Full stop. Various aspects were considered by respondent to pass the following operative. Various factual aspects were considered by respondent to pass the following operative order. Page 48, bracketed portion. By another order dated 11. By another order dated 12/1/22, the interest was denied to the petitioner. It appears that the petitioner was the successful bidder in the tender process, which was undertaken for the purpose of awarding contract for supply of the powder in the drought hit Chikkaballapur district. The petitioner supplied 166.45 metric ton dry powder and could not supply the balanced dry powder in terms of the requirement. It further appears that the petitioner submitted total bill for payment for a sum of rupees 69,25,645. The same was considered. As the same was not considered, writ petition was previously filed. Writ petition number 3725/2020 was previously filed, in which order dated 28/10/2020 was passed, and sum of rupees 60, an amount of rupees 36, 54, 472 was paid to the petitioner, which was acknowledged. Full stop. Full stop. One more petition was filed. One more petition number 6603 of 2021 was filed, which was not entertained, but the petitioner's representation was directed to be considered. Full stop. The present petition paragraph was a third round of litigation, whereby the petitioner complained of insufficient payment towards order supply. It is the case of the authorities, it was the case of the authorities that the petitioner was asked to submit documents in respect of 602 metric ton of green powder and also other documents in support of his claim, but no such material could be produced by the petitioner. Not only that, it was the case that the amount paid to the petitioner, rather included the payment towards the said 602 metric ton of green powder also. It was the case that 1 metric ton of dry powder was equal to 3 metric ton of green powder for the payment, and accordingly the calculation was made and the amount was paid to the petitioner. The petitioner claimed that he was entitled to 72,12,262. Learn a single judge considered the controversy paragraph to record that supply order dated 30th/5/19 showed that the petitioner was to supply 300 metric ton of powder, and it was an admitted fact that the petitioner could supply only 166.45 metric ton of dry powder and was unable to supply balance of the dry powder. Petitioner was permitted to supply green powder in terms of supply order dated 30th/5/19. Paragraph. Following was recorded by learned single judge on the page of the material on record. Then page 19 of the order, paragraph 6, bracket portion. It starts like that, ... order of second respondent, so and so, so and so. Has been made to the petitioner. A case sought to be put forth by a petitioner. The ratio of 1:3 was for feeding the cattle and not for the purpose of payment. Full stop. This was an issue to be gone into by examining the facts and leading evidence, rightly viewed on a single judge. Then again court. Rightly viewed on a single judge, extracting from the same paragraph 6. Then another bracket, whether it is for feeding of cattle for the payment of the disputed question of fact. वहां से लेकर balance amount. Paragraph. From the controversy it could be figured out that the amount claimed by the petitioner was not an admitted amount. Full stop. The case of the petitioner required a definite going into facts and leading of evidence. Full stop. Such exercise could not have been undertaken in a petition under Article 226 of the Constitution. Full stop. Paragraph not paragraph. In the said view, learned single judge has not entertained the petition. Since and it's entered the petition, observing that it involved disputed questions of fact. Also, learned single judge has reserved liberty for the petition to approach the civil court. Paragraph. No error could be booked in the judgment and order of learned single. No error could be booked in the view taken by learned single judge. The challenge to it is meritless. The appeal fails, it is dismissed.
One submission, Lord. Sorry, Lord. So one submission, Lord, in this matter. Lord, they failed to, Lord, the learned single judge failed to understand the fact itself. Fact is this, Lord. Lord, the 2019, Lord, the tender was called to supply, Lord, the dry fodder, 300 metric tons. Lord, out of which, Lord, 164 metric ton was supplied. Because, Lord, due to heavy rain in the, Lord, the North Karnataka, Lord, the dry fodder was washed away. Lord, which is within the knowledge of, Lord, the government. And also, Lord, it is brought to the knowledge of government. Then, Lord, what they did say is, Lord, yes, Lord, you supply the green powder. But accordingly, not only for, Lord, this Chikbalapura district, even other district also he has supplied. Lord, for other district, he has paid the amount. Only for this district, Lord, what happened, Lord? They asked, Lord, the 40% commission. He did not give the commission.
Learned advocate for the submission and इसके बाद learned petitioner.
Lord, one minute, Lord, if the facts, Lord, correctly understood, Lord, the result will be the different.
0.47, whatever it is. Metric ton of powder was supplied and the rest of the powder would not be supplied due to heavy rain. It was submitted that
Lord,
in the other district, the
Lord,
payment was.
it is not disputed fact that either Lord, the dry powder or the Lord, the green powder supply. There is no impunity or infirmity in the supply, which has been accepted by the Lord, the respondents. Even Lords in their order itself, they did not deny that, Lord, I have not supplied the Lord, the green powder or the dry powder. Lord, the dry powder is concerned, Lord, he has paid the amount. Green powder is concerned, Lord, 602 metric tons I had supplied the Lord, green powder, out of which, Lord, they did not, 14 months, they did not pay the amount. Then, Lord, I approached this honorable court. After filing the writ petition, Lord, half of the amount he had paid. Lord, in the writ petition, Lord, the single judge, Lord, order, reconcile the account and Lord, the pay the amount. Then, Lord, after, Lord, they did not reconcile the, Lord, the amount. And then, Lord, I have given a representation. Lord, they went on to issue, Lord, this endorsement. Lord, I will consider 1:3, Lord, the proportion. Lord, it is very difficult to supply, Lord, 1:3 because 500 kilometers from Hubli to Bangalore. Lord, one time coming is equal to 3 times coming from the trucks. But what is the petrol and Lord, other charges and all? Lord, that, Lord, the learned judge, Lord, single judge failed to, Lord, the take into, Lord, those account of the facts, Lord. In fact, Lord, the rate is not disputed, nothing is disputed. Other districts, Lord, they have paid the amount.
Learned advocate further submitted that the green powder was supplied and for which the transportation and other expenses were incurred, which was not considered by learned single judge. Full stop. All these aspects adds to the disputed questions of fact to aggravate the dispute on facts. Same.
Number 35, to Sachin PS.
It's appearing for the appellant, Lords.
What is it?
Lords,
Appeal.
Lords, the writ petition, Lords, was filed seeking writ of mandamus.
Hmm.
Lords, to inspect and regulate and take action regarding the construction, my Lords, by respondent number 3. Respondent number 3 is, my Lords, the neighbor.
Who are you?
My Lords, the neighborer of the respondent number 3.
Neighbor.
Neighborer.
Neighbor sought a writ of mandamus.
My Lords, because he has constructed, my Lords, his balcony over my scheduled property, my Lords. Lords may see at page number F, the page number 61, my Lords, the photograph. Lords, his balcony, my Lords, is over my property.
Again, same thing.
Lords, I have not, my Lords, the single judge dismisses my writ petition on the ground that on the submission of the respondent number 3 that I filed a civil suit. Lords, I have not filed any civil suit on the same cause of action, my Lords. I am only seeking writ of mandamus, seeking
to inspect the property and see if there is any violation of the conditions that has been issued to the respondent number 3, my lords. The condition, my lords, at page number 58, that there must be 1.5 meter gap between the over the properties. My lords may see at page number 58 the conditions of the license that was issued to the respondent number 3, my lords. Page number 58. Half meter around the building while construction of the building, my lords. I have also, my lord.
The third learned advocate, Mr. So-and-so, for the appellant, original petitioner. The appellant seeks to call in question judgment and order dated 6th August 2024, passed by learned single judge, dismissing the writ petition. Full stop. The writ petition was filed with a peculiar facts with the facts pleaded, which were peculiar to the, which was unknown to the writ jurisdiction. Full stop. The case of the petitioner that he and respondent number 3 were the owners of the adjacent plots. It was stated that the petitioner put up construction after getting the plan sanctioned, whereas respondent 3 encroached upon the area in putting up the his construction. Full stop. Writ jurisdiction was invoked with the aforesaid dispute in background to pray, to make a prayer to direct respondent number 1, Gram Panchayat, to regulate the construction of the building of respondent 3 on the property bearing survey number 137 of /1A of the Udugali village, and to remove the construction. Course of learned single judge dismissing the petition. Rightly observed that mere allegation encroachment by petition number 3 on the property of petitioner was not sufficient to come to a conclusion that it was unauthorized construction, and that the entire issue involved highly disputed questions of fact. The court could not entertain the writ petition involving such disputed questions of fact, observed learned single judge, and that it was stated that the remedy for the petitioner was to file a suit before the civil court. Paragraph. The view taken by learned single judge is eminently legal and proper. No case is made out for interference. The writ appeal is meritless. It is dismissed.
That's one submission. The judge, my lord, told that I have already filed a civil suit, my lord, but I have not filed any civil suit on the same cause of action.
Not filed. Then you file now.
My lords, at least that observation, my lords, maybe.
That we have not said that you already filed.
Lord,
Said that it is open for, that remedy is available for you to file civil
the
suit.
judge holds that I have already filed it, my lord.
Not filed is not filed, sir. Next.
36, submit, yes.
For the appellant's counsel.
Delay.
There's a delay of about 150 days. My request to Lordship, we should notice as far as that is concerned, because we actually, we approached the review court also, my lord. So there is some delay because of that. The urgency, my lords, is this. Now, when we approached the learned single judge, we had challenged 4 levies, my lord, which were levied by the Bangalore Water Supply Board. Now, the most prominent levy, my lords, was something called the advance probable pro rata charges. There was a batch of petitions, my lords, wherein there was a challenge to, among other things, is advance pro rata charges. Our challenge, my lords, was specific to the aspect that this advance pro rata charges relates to water connection and sanitary connection, whereas we are not even asking for sanitary connection. So therefore, you cannot levy pro rata charges insofar as both are concerned. The demand was stayed.
There is a delay, will issue notice.
No, my lords, may I just one aspect, my lords, if one observation may help us, only for this reason, there are about 600 units, sorry, 160 units, about, my lords, about 600 odd people living in these apartments. If my lords were to kindly see the IA number 3, which is, my lords, may kindly see page 217. After the disposal of the writ petition, the page 217, my lords, at page 218.
IA number 3.
IA number 3, my lords, running page 217 at page 218. The last paragraph, may I read, my lords?
Yes.
Further, you are hereby directed to pay the charges which were not paid earlier, that is pro rata charges and other charges within the period of 7 days after receiving this intimation letter, and make an online application. Treat this as utmost urgency. Else the water connection will be disconnected. There's another letter, once again, my lords, reiterating the same. My lords will find that at page 223 and 224. I had the benefit of an interim order throughout the pendency of the writ petition. My grievance is,
Without considering delay will not.
I'll take notice for
let them
record
not
number 1.
disconnect the water, because I'm on a very limited aspect.
Any other party and the government?
The
I'll
water
take
supply board.
response
Water,
number 1.
government is only a formal party.
Water supply board is there.
We'll keep it on 14th of November.
Very good.
Notice written on 14th November. Notice in CA as well as IA as well as
Great.
main appeal.
Well, then 15th, well, I'm sorry, I think my
15th.
instructing council have some
15th.
15th. Grateful.
Yes. Number 37. The Sachin BS.
In this case, I seek for short accommodation, my lords, because here is unwell, my lords. A short accommodation, my lords. It may proceed next week, any date, my lords. I will.
14th.
Interim order may kindly be extended. Interim order may kindly be extended.
Interim order is there. What interim order?
That's the case where the learned single judge has directed TDRs to be issued in our favor. We are slum dwellers who had been displaced. That, my lords, the BDA is questioning. BBMP had recommended.
Seeking time, we'll consider on that.
Could I request for 2:30 if possible, because your lordships have disposed the connected writ appeal by the BBMP on 30th September with an understood copy held in. So,
My learned advocate, Mr. So-and-so, prays for time on the ground that the learned senior advocate who is to conduct the appeal is not available. While that it is not convenient to conduct the matter today for learned senior advocate who appears for the appellant. Learned senior advocate, Mr. Anindra, stated that this court has dismissed the.
But dismissed not on merits, my lords. It is not on merits.
Not on
It is
merit.
only on the factum of locus, because the BDA has to hand over the TDR. We had also challenged the order of the learned single judge.
Yes,
So
yes.
therefore, that submission was unnecessary, I feel.
Yes, so they don't
Yes,
mention it.
please.
No,
$10,
lords, I'm only-
$10. You rely on that if you can rely.
No, only that, my lord, that the connect. I don't know why my learned friend is getting, I'm only saying
Simply
there is
14th,
an hurry.
15th.
All
At
contents
the
were
request
kept
of learned
open under
advocate,
BDA's
Mr.
petition,
So-and-so,
my lord.
so-and-so,
We have the liberty
on the
to
ground
argue.
that the learned senior advocate who is to conduct the appeal is not present, $10 to 14th.
14th, can I request 2:30 if possible?
Please.
Subject. Very well, very well.
Interim order may kindly be extended. Sorry, my lord, interim order may kindly be extended.
Interim orders shall continue to operate.
Much
It's already granted earlier.
Like,
Till the next.
Commercial appeal matters, number 38. Hare Krishna Pramod.
Lords, I appear for the appellant. My lords, this commercial appeal is arising out of the impugned order dated 4/9/2024. It was a commercial suit filed for trademark infringement, my lords. Along with the suit, an application under Section 12A of the Commercial Codes Act was filed to dispense with the mandatory pre-institution mediation, my lords, because the suit contemplated an urgent interim relief, my lord. Along with that, an application for temporary injunction was also filed. However, the learned trial court has not only dismissed the application under Section 12A, but they've also dismissed the suit preliminarily, my lord.
Arbitration Act. Sorry, commercial code, sir.
12. Section 12A, ma'am. My lords, section 12A states that a suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff
It
exhausts
was a
the
suit
remedy.
for infringement.
Please, my lords, it's for trademark infringement. Hence, in view of the urgent interim relief that we had sought for in the suit, we had instituted the suit foregoing the mandatory pre-institution mediation, which section 12A provides for. The classification is created in section 12A, which says that only in the absence of an urgent interim relief, the mediation proceedings is mandatory, my lords.
No urgency. Your rectification application is also.
My lords, I will clarify regarding the rectification proceedings. The rectification proceedings was only instituted insofar as the word mark was concerned, my lords. The plaintiff has been using the word Kaveri.
Let's have the other side. We'll take up.
Please, my lords, notice mediation.
Notice returnable on. Twentieth November,
Please, my lords, grateful.
not 20th November. 26th November.
Grateful, my lords.
It is observed that looking to the compass of the controversy, the court may, don't say that. To be listed at 2:30, looking to the compass of the controversy.
Grateful.
Number 39. That's better appear for the appellant, my lord. I seek for a short accommodation in this matter.
Here for the respondent in this, my lord.
26. 26. Yes.
For the appellant, my lord, I seek for a short accommodation in this matter, my lord.
Here for the respondent, my lords, in this matter.
All right. When do you want?
Any date next week, my
Tell
lord.
the date, next week. 20th. No,
Yes, my lord. Grateful. Interim order may kindly be extended.
interim order shall continue to operate till the next. What is
Obliged.
Arbitration matter, my lord, for specific performance.
It's against an arbitral award, my lords.
Yes, next.
So 40 urgent, so 41, Tanup, Sitaram. Number 41.
I appear for the respondent number 1 in this case, my lord.
I am for the appellate.
Yes.
My application has been rejected. Consequent upon dismissal of application for condonation of delay. The reason for not condoning the delay without appreciating the submissions made by us could be found at in page 32 of the order of the learned district judge.
Delay of how many days? 30 days.
28, my lord, the court had power up to 30 days. There was delay of 28 days. That delay has not been condoned. Section 34(3) clearly provides discretion to the court. Says I have not made out sufficient ground for condoning the delay.
My lord, may I make a mention?
So 90 days is total period available.
But after that, 90 days is the period provided.
court has discretion to condone the delay of 30 days. Kindly see section.
That's right. Therefore, outer limit is 90 days.
My lord, may read subsection 3, proviso, my lord.
We have seen it. Therefore, total outer period is 90 days, 30 plus 30, 60 days. Not 90. It is
Right.
60 days.
3 months, my lord, an application for setting aside may not be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award, or if request had been made under section 33.
You come physically, come, put list on 8th of
My lord, 8th is the date on which execution is posted, my lord.
7th.
I had the benefit of stay throughout.
7th.
My lord, this MFA is not maintainable, my lord, because the designated court, Kyle court has passed an order on IA filed by them. So they have to file the commercial appeal, my lord. I strongly oppose the granting of stay, my lord.
Better you argue physically since you are.
MFA cannot be maintainable.
Yes. Next.
So review petition, number 42, Mr. Muralidhar HM.
Obviously.
For the petitioner, my lords, today senior's father's death ceremony is there, my lords.
3rd December at the request of learner of the review petition.
May be taken on 8th, my lords.
Not possible.
Number 43, Sir, Mr. Anandaram K.
I appear for the complainant. As last 2 occasions, your lordship may kindly peruse the orders passed, my lords.
The complaint has been done, my lord. I am filing the complaints affidavit. It has been done. Needful has been done, my lord. I'll pass on the.
So orders are passed by the.
But subject to the outcome of the writ appeal, my lord, the revenue entries have been transferred, my lord. Para 4 may kindly be seen.
Then it is good enough.
Yes. Needful has been done, my lord. The name of the petitioner.
30th 9/24, the following order was passed by this court. Then quote the entire order.
Reading document.
Today, when the contempt proceedings came up for consideration, learned additional government advocate, Mr. Paris, filed a compliance affidavit in which it is stated earlier that
Para 4.
RTC has been entered in the name of the complainant to the extent of 4.50 cents of land in survey number 288, Paduvu, PADU View Village, Mangalore Taluka, which is made subject to outcome of the writ appeal filed. Writ appeal number 1303 of 2022 filed by the appellant state. In view of the above, comma, nothing survives in the present contempt proceedings, comma, it is disposed of, comma, the rights of the party shall be governed by the minor order which may be passed by the court in the writ appeal.
Lovely.
Number 44, Mr. Shrikant MP. In this case again, my lord, better affidavit has been filed.
So after, my lord, the order of this honorable court, the, my lord, state has filed, my lord, an
A
affidavit.
better affidavit has been filed, my lord. 24th October 2024, my lord, complying with the order.
One submission, my lords,
Para
just
3 may
bring to
kindly
the
be
notice of this honorable court. Page number 14, my lords, in respect of condition, my lords, which are there in respect of, my lords, the order approving the appointment. That is page number 14 in their account, my lords, counter affidavit.
What was to be complied with?
My lords, the order of this honorable court on WP 2527 of 2023, my lords, approving the appointment.
It is done or not?
Please, my lord, it has been done.
Lords, afterwards they have done, but your lords may kindly have a look at, my lords, page number 14, condition number 1. They say it is subject to the result of the writ appeal as against the order of the learned single judge. Page number 14, my lords, of the count, my lords, of of the, my lords, which is filed now, my lords, the better affidavit, what they say. My lords.
That is the same.
My lord, writ appeal itself is not filed, my lords. I have produced, my lords, my lords, the communication of the government. It says is not a fit case for
It has
appeal.
been filed, my lord. Writ appeal has been filed. It is passed subject to the outcome of the writ appeal.
The council said it is not filed.
I checked right now also, my lords, it is not.
Instructions
filed.
and submit, my lord. I will take instructions and submit and furnish the case number, my lord. The
The
appeal has been
compliance of
filed.
the order is indicated by the respondent to be subject to the writ appeal, which is stated to have been filed, which is claimed to have been filed.
Please.
Full stop. The endorsement issued by the competent authority reflects in its condition number 1 that such writ appeal is filed. Paragraph learned senior advocate to the petitioner stated that there is no such writ appeal is filed and there is no detail about the appeal available on the website of the High Court even. Full stop. Learned additional government advocate, Mr. Harris, to take correct instructions
Yes,
to be listed on
Week after next. month.
6th of November, day after tomorrow,
Very well.
7th of November,
I will apprise the court, my lord. upon-
at 2:30.
Please.
The complaints in contempt matter, still number 45.
It is not filed.
Lord, I will verify, my lord. I am not aware of
So
the fact. I
we
will,
already, my brother is already very.
I will apprise, my lord. Otherwise that condition will not.
Anyway,
survive.
7th.
Otherwise that condition has to go.
Yes.
For the complainant,
Fine.
my lord. They have filed and complaints affidavit. I have sent across to the client, my lord. I'll verify and submit, my lord. Okay.
You,
Complainant, my lord.
so what will verify?
They have filed an affidavit with compliance with an endorsement
that?
wherein they called upon the
What were the direction?
direction to sanction the sanction plan, my lord, up to sanction plan.
Sanction the plan. Consider applications submitted petitioner for sanctioning layout plans.
Yes.
They have sanctioned?
They have sent an endorsement calling upon to pay the fee. I'll verify and make my
Directed to
submission.
consider the applications. What is to be verified? Where is your affidavit?
They filed the affidavit on, with an endorsement, my lord, wherein in the last para it says that to
In last,
pay the,
it has been considered to approve the levy plan for the residential purpose for the lands in.
Which page?
My lords, page number 10.
Page number? Page number
10
10 of what?
in compliance affidavit,
Compliance dated?
dated 3/7/20.
Hmm?
3/7/24.
3/7/24. Hmm. 27/6/24.
Please,
37 is not there.
27/6/20.
filed on
27/6. Page 10.
page 10. Last.
It is approved.
They have called upon to pay the fees and
Fee.
ascertain and
Ah.
a week's accommodation. I'll verify and make myself.
What is to verify? You can verify day after tomorrow, on 7th. This contempt came to be filed in respect of alleged non-compliance of the following direction. Passed by Learner Single Judge in his order dated 7th February 2022, while disposing of the writ petition. Then quote from page 23. 1 and 2. It will be 2 and 3, but in your 1 and 2. Thus, as per the direction, the layout plan for the residential purpose was to be considered, which was the application already made by, for which the application was already made by the petitioner. Full stop. In the compliance affidavit dated 27/6/24, endorsement dated 14th May 2024 is produced by the respondent, in which the Chikka-Ballapur Urban Development Authority has stated thus on page 10, quote, stated has produced the in which it is stated thus, extracting the final paragraph, since it has been considered. Therefore, it is clear that it is approved.
After payment of the.
Thus, it is clear that the layout plan is approved and the approval is subject to payment of the fees by the petitioner, for which the petition is called upon to pay within 90 days. Full stop. In the aforesaid view, nothing survives in the present contempt petition is disposed of. Full stop. Liberty is reserved for the petitioner in case of difficulty to revive the contempt petition.
46.
Same.
46.
46 same.
Same.
46 same.
Number 47 to Vijay Kumar L.
Hearing for the respondent.
To Vijay Kumar L. 47.
Complaints affidavit as submitted. Complaints
Who
affidavit
appeared?
submitted. R3.
Who is for three? Nobody is there. Compliance is keep back. 230.
Number 48.
48.
Sunil
my
Kumar
lord,
Patel.
There was a compliance affidavit which was filed, my lord, but the court wasn't happy with the compliance. My lord, in this I require some time, my lord, in this matter. That is 48,
5th December at the request of Law and Additional Government Advocate,
please, till 51, my lord,
Sweta Krishna.
till serial number 51 is the same issue.
51 is also same.
Please,
Same.
50, 51 and 49, 50, 51.
49, 50 and 51.
51. 5th December. Number
Much obliged. my lord.
52. Mr. Ajit Kalyan.
I appear for the complainant in this matter, my lords. I appear for the complainant in this matter. The compliance affidavit has been filed, but the emails attached along with the compliance affidavit are of 2021. The writ was filed in 2022 for further complaints. This is not a disputed case at all, my lord. Partially, the banks have credited the amount, which was frozen. I have filed the writ only for the further expedition of crediting of amount from different accounts in each bank, my lords, in this matter. The compliance affidavit cannot be considered in this matter, my lords. As far as the office objections with regarding to the names of the accused, my lords, I have asked the client to find out about the names, and 2 weeks time may kindly be given. I'll verify the exact situation and I'll make the necessary submission, my lords.
Where is your affidavit?
My lord, affidavit has been filed on 21st September 24, my lord.
Subsequent to the writ order, they had emailed the bank, my lord, as far as the compliance
Allowed,
affidavit is concerned. Subsequently, partially the amount has been credited. We are not disputing that.
Complaint has to be
Affidavit
done by the bank, my lord.
Has been filed, the main writ has been filed in this only with regarding to further deposit, my lords.
They have issued direction to the bank.
We have given the direction to the bank, my lord. It is bank for the bank to defreeze the account.
Then the direction was to whom?
My lord, respondent number 1 is to issue a direction to the bank to defreeze the account, my lord. The directions have been issued. Now it is for the bank to act upon.
My lord, since that was in 2021, the report has been filed in 2022. I'll ascertain as to the exact amount which has been
Ascertain
created.
it.
2 weeks. 2
Not
weeks
2
time.
weeks. On 8 at 2:30.
8 at 2. Much
Learned advocate, Ms. So and so for the accused wants to take instructions regarding the compliance. Inasmuch as the compliance affidavit states that the directions are complied with. Paragraph. In order to enable learned advocate for the petitioner to take the instructions up at 2:30 on 8th of November.
Number 53, Mr. KV Satish Chandra.
This case, Lord, so I filed an objection statement. Short accommodation from the filing.
Why?
Because he filed an endorsement, Your Honor.
What
And
is
I
your,
filed an detailed objections, what are the happens in the previous days and writs and all these things. Now they have to go for the parallel proceedings also. Only just entering into my name into the Pani, Your Honor, that's it.
it is done or not done?
My lord, the para 6 of the affidavit, my lord, we have explained.
Para
my lord.
6 of the
20th
affidavit.
September 24.
I filed that
Proceedings have
detailed
been
application.
initiated and inquiry proceedings. have
Some
been issued.
endorsement is issued.
Endorsement has been issued.
Yes. 10/7/24. Is it correct? 10/7/24.
Please move.
There are 6. Let us see.
But I filed all the documents, Your Honor, with permission.
But what are the directions?
Direction to, in the last para, Your Honor, to enter into the name of the petitioners, Your Honor, complaint. It is a long, but after the computerization in the Pani, the respondents is not entered into my name, Your Honor.
But
Because
proceedings
all the
are,
documents is there.
proceedings are initiated.
Proceedings are initiated and endorsement has been issued.
Once again, they have to proceed proceedings, Your Honor. It is since 2000 year, you to take the several steps, Your Honor. Detailed order was passed by the learned judge, Your Honor. Detailed order. All the proceedings was to be passed, Your Honor.
But this endorsement dated 10/7/24 shows that the actions, proceedings are initiated.
Yes, my lord, proceedings were
That's it.
initiated and endorsement has been issued. If they are agreed by.
Now I filed that endorsement to do,
Under
file
section-
an objection statement, Your Honor. For that endorsement, I filed an objection.
Query under section 136(3) of the Karnataka Land Revenue Act. That is initiated.
Please.
Because I filed an objection and detailed records is there, Your Honor. Because all the records is there. They have to often and often to initiate the proceedings, Your Honor. Then finally, this lordship is to be single judge to pass in a within, shall is used within a 1 month. First, you have to enter in the name of the petitioner in the Pani. Then you can to take any action, Your Honor. But they have, once again, they have to file an endorsement. So many times, so many litigations is there, because in the last para, Your Honor, in the meanwhile, if the petitioner approaches the Tahsildar seeking continuation of his name, computerized Pani, the Tahsildar shall consider the claim of the petitioner for continuation of his name in the computerized Pani. The Tahsildar shall not decline to consider the claim of the petitioner on the ground that no grant was made in favor of the petitioner. If the Tahsildar is of such opinion, then he move the competent authority to invoke the suo motu powers under section 136 of 3 of the Act, which is also akin to the orders passed by this Honorable Court, Your Honor. If such action is to be initiated, it shall be initiated within a period of 1 month from the date when which the petitioner approached the Tahsildar seeking revenue entries. If suo motu proceedings are not initiated within such period, the Tahsildar shall proceed to enter the name of the petitioner, Your Honor. After filing the memorandum and this petition, they have not entered up to 3 months or 4 months.
Now-
Finally,
Now it is initiated. 136, 160, 136(3) initiated.
but one submission, Your Honor. But first he entering into my name. If there is any concluded their deputy commissioner
That is the
order,
view that. Question. You just look into Mr. Harish.
Please, my lord.
The observation at page 13 of your endorsement.
Please.
That there is suspicion that why re-grant has been sought if the said land is not a Gomal land.
Yes.
And that if it is granted land, hence there is no provision for considered representation. Now, order says that this should not be a ground.
No, my lord, the notice has now been issued, my lord, for holding of an inquiry, page number 16 of my affidavit, my lord. An inquiry notice has been issued, my lord, to ascertain the fact of the matter to the
But
complainant.
based on this ground,
Yes, please, my lord. He has been asked to furnish all the documents, my lord. in
Because I
support of his
already
case.
produced the documents so many times, Lordship.
That is
Still,
not-
I'm ready to, I produced the
is
certificate
not the
copies,
case.
Your Honor.
That is not
Grant
the-
certificates and our old RTCs, I'm ready to produce
Just-
before
you
this
just-
court.
I will
your
ascertain.
authority and then
Please.
come, then explain.
Very good.
What
I
does it-
one,
what does it-
two sets of original certificate copies I produced by this court. Your Honor.
My lord,
13.
authority has issued a notice asking him
13th,
to
you
appear
just
along.
Call your office
Please,
and
my lord.
ask yourself.
Please, my lord, I will
13th
take it.
ask.
Much obliged. I produced the documents, Your Honor.
All right. Do whatever you want to do.
Much obliged.
Number 54 to Bola Vedavasa Chennai.
My lord, I'm for the complainant, my lord. My lord, they have not complied with the order of the,
Complied with.
not complied, my
Not
lord.
complied.
And in fact, my lord, they had filed a review petition and review petition has been dismissed with a cost of 98,000 rupees on them. And for producing a copy of the,
Now you comply with subject court complaint.
Some of the
This is order,
complainants are already appointed.
order 2023. What is very direction?
my lord's page number 29, ma'am. Annexure A. Paragraph number 2, my lords, of the order.
Employment within 2 months.
Yes. Within 2 months, my lord, and these are all Group D employees, my lord, peons, gardeners, they're poor litigants, my lord.
And some of the complaints already taken place of the work, my lords. Some of the complainants already taken place.
No, no,
Taken in service.
no, no, my lord.
Please, madam.
He is saying,
He's already working, my lords. Some
No,
of
my
the
lords.
complainants.
Let them produce, my lord.
Please, ma'am. Next date I will produce.
who are working?
I will get instructions, madam.
In-
Numbers.
Shall I record or shall we record your statement?
Please, ma'am. Please.
Learned Council, Mr. So and so for university.
Please.
Stated that some of the respondent workmen are already in service.
Sir,
Are already in service.
Lord, they have been appointed, my lord.
What does it
As,
mean?
as per our instructions, some of the employers are already, started appointments. So,
That is what we are recording, already taken in service.
my lord, we will seek the instructions, my lord. We will update the status.
Whether you are making statement or not making statement.
Lord, our instructions are
As
such.
per instruction, my lord, they are
Per
working.
instruction.
Please.
That some of the
Complainants.
respondent workmen are already in service. Also, such details will be submitted by the Learned Council on the next day. Put up on 12th of December,
Please.
12th of November at 2:30.
Grateful, my lords.
We will
Well,
take
what
it.
about the writ appeal?
Writ appeal number 1519, my lords.
15,
19 of 24.
19 of 24, when it is coming up for,
They have not complied with the office objections.
That we will not file, some other.
You give details of this, whosoever in service on 12.
But in fact,
If you are turning out to be false, then we are coming out with very heavy hand. If the statement is false, very casual, it will be very casual. Till you are sticking to it. So we are directing you to supply the details. If it is wrong, we will come out with very heavy hand. Please mention, please remember. For taking the court proceeding very lightly and cursorily.
no one.
It appears from your approach. Next. To be listed at 2:30 on 12th.
Serial number 70, my lords. The same had order has been challenged in writ appeal
Which one?
1346, my lords.
Serial number?
70,
17,
70, my lords.
70. What do you want?
Yes, my lords, the same appeal, same order has been challenged in writ appeal 1346 of 2024, my lords. It may be connected along with the writ appeal
To be listed with writ appeal number
1346 of 2024.
134624, in which the very order is under challenge.
Please, my lord.
Also,
And my lords, meanwhile, I may be permitted to comply with office objection.
The law
Shall be complied with in the meanwhile.
Must may I mention a matter, my lords? Item 57.1. But today I filed the wakalat, my lords. I have received the file yesterday. It can be granted 2 to 4 weeks time. my lords.
55.1,
57.1,
57.1,
57 and 57.
PIL.
Yes, my lord.
Let us see what is it, when it is called.
Those may be fixed, my lord, otherwise. I appear for respondent number 5 and 6, my lord.
We do not know whether nobody has asked for that. Wait.
Crossover matters, serial number 11. Serial number 11. Mr. Keshav K.
None was present in the first half as well as in the second session, full stop. The contempt petition was called out on both the occasions. It could have been dismissed for want of prosecution or in larger interest of justice, extend out 3rd December.
This is serial number 12. Mr. Jagirdar. Serial number 12.
Same.
Serial number 47. Mr. L. Vijay Kumar. 47.
Aim for respondent number 3.
You are for respondent.
Respondent number 3.
The only, he is not there. You have filed, it is complied with.
Please, my lords.
Where is that?
Affidavit is filed.
Affidavit
Page
is
number
filed.
1 is the compliance affidavit.
Endorsement is
Endorsement is at page number 18.
18.
Dated 9/8/2023. We have considered the representation and some part payment also made.
It is in his favor.
Please.
Endorsement. Hmm? In his favor. The only direction in the order of Learned Single Judge dated 28th March 2023 was of directing respondent 3. As the horticulture produce cooperative marketing and processing society limited to consider the representation dated 11/5/2022 of the petition within stipulated time. The court issued notice to the respondents in this contempt petition, pursuant to which compliance affidavit is filed by respondent, in which copy of office order dated 9/8/23 is produced. The said office order paragraph in its relevant part reads as under पूरा कोड कर देना है page 18 पर with reference to say करके installment. In light of the above, the following order came to be passed. Extracting the operative portion. इसमें दूसरा part as narrated above, वहाँ से right. In view of above, the directions are complied with. Nothing surprise in the present contempt proceedings. The petition is disposed. Coded.
I take notice for art home and government appears for art home.
Yes, Alifan. Learned advocate, Mr. Learned Krishna, as well as learned additional comment advocate. What is your good name?
Shweta Krishnappa, my lord.
Yes, that.
Shweta Krishnappa.
We know, what is your group?
Sorry.
N. Ramchandra. N. Ramchandra, as well as N. Ramchandra, for 3. Invited attention of the court to the compliance as 10.
So 115. Lord, 114, my lord, I'm sorry. 114.
Pardon?
114, my lord. I had mentioned it in the morning, Lord, Lordship said direct.
That is kept on 13th November.
Great.
We'll see what.
Great.
Lordships, without going into the merits of this case, I would just restrict my submissions to the fact that the petitioner, pursuant to the orders of this honorable court, had attended the second year classes. Thereafter, pursuant to the direction of this honorable court, she's taken the examination and passed the first year. Now, to make us go through the first year again would be more punitive than constructive. The certificate I have produced, past certificate, and she's got the attendance, and she has taken 4 of the internal examinations
But
of the
you-
second year also.
We have noted in the order, but only question which crops up is in my mind at least that
Please, Your Lordship.
you failed in the first MBBS.
Did not have the aggregate 2 years, 2 marks. 2
How
marks,
to- To cure it,
but that now she has passed. She has passed the first year.
first year.
Yes, yes. I've produced the certificate. Past certificate, she has passed pursuant to the direction of this honorable court, permitting her to take the examination. Then she has attended the second year, so she has this, she has the attendance. She has taken 3,
The second year is attended.
yes. That is also pursuant to the direction of the honorable court. She has taken 3 internal second year examinations. And now she's before this honorable court seeking a direction that she may be permitted to take the final examination of the second year. Because now telling her to go back to first year would be only punitive, Your Lordship. In fact, in similar cases in other universities, like in the case of veterinary college and all, we have permitted. And where I have also produced the judgment of the Dharwad High Court, Your Lordship, wherein Kalburgi High Court, wherein grace marks were permitted, and the writ appeal has been filed by the Rajiv Gandhi University, but they have not pursued the same, and there's no interim order either. So those students have passed, and they've also been promoted. Produce the additional.
5922, ordinance.
That is the ordinance by which they said that grace marks could not be given.
Regarding other petitions.
Which one?
Regarding revaluation.
Ah.
No.
That is regarding revaluation, Your Lordship. That is not, we are not concerned with we never sought for revaluation. The judgment deals with the various issues.
So what are the relief granted during the pendency of petition?
There were 2 interim orders, one permitting me to attend the second year classes, and the second interim order was permitting me to take the examination. Supplementary examination, both of which I did. Therefore, I've got the attendance for the second year. Supplementary exam, I've passed the first year. And I produced it at 267. Document 1.
Then the petition is dismissed.
Please, Your Lordship.
Petition is dismissed.
Petition is dismissed.
So you did not request learner single judge that
No, the results were announced.
results were not declared.
Results were declared pursuant to the disposal of the writ petition. Of the dismiss, the matter was reserved. While reserving the matter, the honorable judge permitted us to take the examination.
Yes, what do you?
That's the main issue before the learned single judge was which of the regulations of the apex body apply to the petitioner hearing. Petitioner is admittedly RS3 batch, RS4 batch, who are the batches after 2019. Prior to 2019, there was a provision by the apex body providing for 5 grace marks for a student in a certain circumstance. But the petitioner is person who was admitted after that batch. So they went before the learned single judge seeking for award of grace marks, which the learned single judge denied. Having denied the matter, my lord, she appeared during the pendency of that, but the writ petition was dismissed. Against that, the present writ petition has been filed. The present writ petition, writ appeal as I read, is based on requirement that the court did not take note of a judgment of this honorable court in terms of page 254. Kindly see page 254. The order of another learned single judge at Kalburgi. This is the main contention as to the writ appeal. Kindly take page 253. Para 9 and 10. Para 10, let's para 9 records a finding that the examinations after 1/8/2023.
So this is a matter decided by Kalburgi bench.
Yes.
Please,
my
Your
lord.
Lordship. No, I will not.
This is a judgment decided by the Kalburgi bench, but there is a error apparent on the face of this order. Para 10 may kindly be seen.
So your friend is relying on this order.
Yes,
Same
to
judge.
say that the learned single judge ought to have taken note of
So
this
she is relying on merits,
on merits, yes,
on merits,
yes.
about that grace mark.
About the grace marks. Let's see, the Kalburgi bench unfortunately recorded an erroneous finding which is contrary to the fact. Para 10 says, admittedly, the petitioners are seeking for grace marks to be awarded for the earlier examination to 1/8/2023. It's factually incorrect. They have taken the examination in February 24. So therefore, the admittedly is something, lords, which the court has recorded without any base.
Probably,
They sought for
counsel's
implementing the
argument is
judgment.
that any of the subsequent development,
No, there's a further development to that. What? Furtherance of para 10 order of the Kalburgi bench. The court directed them to consider a request in that case. It was considered and an endorsement was issued. That endorsement was again challenged by the petitioner.
Same petition.
By the same petitioner, saying that this para 10 has been not taken note of. The court adjudicates on that and says it's a mistaken notion, dismisses that petition. That has not been pointed out in the writ appeal. We have the orders. If the lords permit us, we'll take some time to file our objections to this on the main matter. Fact remains, the second petition by this petitioner in Kalburgi bench has been dismissed on merits, saying that this is an erroneous assumption and therefore is not correct. The second aspect is, lords, my learned friends.
we have placed these developments on the record about passing of the examination.
I have filed an additional statement, Your Lordship.
Very.
That is, then IA at page 262.
This was not there.
Without going into the merits, because now the grace marks would not arise for the simple reason that she has passed.
Only in December, without this week, 1 year ago, started in December 24. To give them. If that is the only grievance, lords, I would like to make one statement.
Yes, that's the only grievance.
was it last year? 1 year. August 2024, she appeared in the exam. From 10 to 2024, she started her. Only after 1 year. The next, she has to complete 1 year of her. Even if you take April to April.
So she will become eligible in
April, after April, any exam, it will be in December. Next, because in February, one exam will be in January, one will be in March. And then in March, next will be December, November. That's depending upon the course. Even if you take that one tomorrow. Attendance can undo 80%.
If you really want to file something, we'll grant time, otherwise we'll dispose of the case.
Please give us a week's time, my lords. Only aspect is, her grievance appears to be that she had the benefit of attendance during the pendency of this. The law on the point is that once the writ petition gets disposed of, dismissing, the benefit of interim order goes. Even otherwise, there's a bar under the statute that you can't progress to next class until you pass the first year. Now, according to her, she has passed her first year in an examination taken in April. August. So she has to attend 1 year from August to next August. Whatever benefit of attendance she is entitled to will be given. But next exam is going to be only in December 25. Permit we have no, and that's a different cause of action. So you can always urge that in a properly constituted writ petition explaining how she is entitled to a benefit of that attendance. I want to put that in writing, my lords, if your lords permit.
You can do whatever you want. By 13th, on 13th we'll give.
Lords.
13th.
Yes, your lordship, the last day to pay the fees is 7/11. That is why I was,
7/11.
tomorrow they should not raise that as another ground. I have produced, that's at document number 2.
6 months you cannot appear.
I was hoping that the university would be less, would be more magnanimous when it comes to a student rather than.
Which apparently she's asking for appearance in the examination scheduled for this December. She has not even attended 6 months.
Last date is 7th.
Please, your lordship. 7/11, 22/10 to 7/11 was the last online filing of application.
Exams are in December 20.
For MBBS examination.
Please, second year.
Please wait. Okay.
Will permit her, my lords, after your lordships hears us on marriage.
No, online.
Online.
15/11.
Thereafter, your lordship, it is with fine, and then payment of examination saying without fine is from 22/10 to 7/11.
25/11 is the last.
Sorry, your lordship.
25/11 is the last.
Yes, that is with fine. Yes.
Nothing will happen.
Will not raise such objection, my lords, at the last.
If, if they can be, if they can,
13th at 2/3.
I was hoping that now that since the Honorable Chief Justice has taken the blindfold off from the Lady Justice's eyes, our court, our learned friend would be think more from the heart rather than from the mind. But anyway, I suppose old habits die hard. Thank you very much.
We will only look at the constitution.
She has to put in 80% of attendance in second.
We'll see, let us find out.
Let's tell that, Lord. Therefore, she is not eligible, but then we'll place the record.
Number 55, Mr. Ravindra Gajanan Kolle.
Please, my lords.
Lord, an affidavit has been filed on 9th September 24, my lord, explaining the difficulty in complying with the order, my lord. There is an issue regarding the identity of the land. Para 3 of the affidavit may kindly be seen.
My submission, my lords.
This you can do overlapping, removal of.
My lord, overlapping is not an issue, my lord. Now there is an issue regarding the forest land and the revenue land, my lord. The extent of the forest land has now been shown to in a lesser extent, my lord, in the revenue records, for which proceedings have been initiated before the assistant commissioner, my lord. Therefore, the forest land extent has to be determined here, my lord. And the identity of the land of the complainant is in dispute, my lord. There is no fixation of boundary. He wants to carry on query now with the no objection certificate of the forest department. The issue is the identity of the land is in dispute, my lord. Para 6, we have stated, my lord, that he has to get his land, identity of his land established here.
You file your reply.
May I make a submission, my lord? That land has already been survey measured and 5 guntas was alleged to be falling in my QL applied area, which I said I am going to forgive. And after deducting that, and the previous court previously taken up matter was passed, my lords. The order may kindly be seen at page number 19. That's an order passed by this honorable court. At relevant page at 18, my lords, a small order that I may kindly be permitted to read, my lords. Mr. So-and-so, based on the joint survey, an area of 5 guntas of land found to be overlapped. Petitioner does not press his request to the overlapping area, which is mentioned in the map at Annexure 2, R2, and prayed that direction be issued to consider his application for remaining area of land. Learned government advocate submits that petitioner's request shall be considered within an outer limit of 2 months from the date of receipt of copy of this order. His submission is placed on record. Thereafterwards, this honorable court was pleased to pass directions, 3 directions. First, one is writ petition is allowed. Number 2, order dated so-and-so, produced at Annexure A, and order dated so-and-so, passed by 3rd respondent as per Annexure L are questioned. And 3rd direction is most important for my purposes, my lords. There shall be a direction for consideration of petitioner's request, excluding the overlapping area mentioned in the map at Annexure R2 within an outer limit of 2 months from the date of receipt of copy of this order. That disputed 5 guntas I had already given up, and which submission has been recorded previously by this honorable court, my lords, based on the submission made by the learned government advocate. There is no issue now remains, my lords. And it is only after survey measurement carried out, a map has been produced at Annexure B, my lords. And nothing now remains. And this itself is, and very same facts have been reiterated by the Deputy Conservator of Forests in his affidavit filed in this proceedings, my lords, on 8/8/2023.
Learned single judge,
Beg your pardon?
while disposing of the writ petition, as per his order dated 1st February 2024.
Order of the division bench. Order of this honorable.
Set aside order dated 20th/9/22 passed by Whisper number 2, that's the Secretary, Department of Commerce and Industries. Post of learned single judge further directed to consider the request of the petitioner for excluding the The
The division bench order, my lords, green bench order. Sorry, it is a green bench order, division bench order.
Considering the request of the petitioner for excluding the overlapping area mentioned in the map within stipulated time. For filing the present contempt petition, the petitioner has complained of the non-compliance of the above direction. In response to the notice issued by the court, the Deputy Conservator of Forest, Chikaballapur Forest Division, Chikaballapur, has filed compliance affidavit. The compliance affidavit, the following facts and aspects are stated. One, pursuant to the order and the actions of learned single judge as above, the request of the petitioner was considered. When the measurement of the forest area was done. Tahsildar of the Taluka, without notice of the respondent authority, reduced the area held by him. Since the RTC in survey number 5 of Gumalapura stood to the extent of 12.35 acres and was reduced to 9.31 acres. And 3, the forest area was reduced without following procedure. Therefore, appeal was preferred before the Assistant Commissioner, which was registered as regular appeal number 298 of 2024 as the instance of the petitioner. Next. A serious dispute of fact exists with regard to the forest area and the revenue land, which may be available with regard to the identification of the area in Kumalpura, survey number 5. In view of the above, it is submitted by the respondent that request of the complainant could not be considered in view of the serious dispute with regard to the identification of the area. The complainant has to get the actual area of land identified by a proper survey from 40 and those. The authorities have discharged their duty towards compliance of the order. In view of what is stated in the affidavit, it could not be said that there is any willful non-compliance of directions on part of the authorities, respondent authorities. Contempt proceedings are not maintainable any of the aforesaid facts and the action taken. It would not be said that the contempt is committed. Petition is dismissed with closure of the proceedings.
Please, ma'am.
56, Venkatesh P. Dalwai.
Which one? 56. This was 52.
This suo motu PIL.
PIL.
Then it was referred to High Court Legal Aid Services Committee, my lords, for filing. The subject matter pertains to, my lords, maintenance of parks and open spaces across state of Karnataka. Lords, in terms of the Open Space and Parks Act, my lord, during pendency, my lords, I was
Parks, because of the cover and it is coming. Parks, lakes, that is lake. This is parks.
Parks and open spaces. During pendency, my lords, I was directed to amend the petition to enlarge the scope to the entire state. That is how additional respondents were implemented. My lord, the amended paragraphs, my lords, are in terms of section 4 and 5 of the Parks and Open Spaces Act. May I request, my lords, lordship may kindly take the amended petition dated 6th July 2021.
July.
6th July 2021, my lords, amended petition. Amended petition.
Amended prayer is.
Amended prayer at in page 14 of the amended petition. Paragraph 17. During pendency, my lord, there was one building which has come up on the park. My lord, so the survey, the report was secured with the Honorable Court through BBMP.
Any replies?
Replies, memos have been filed, my lord. We have come on record. Lord, Mr. Srinidhi was appearing in this matter, my lord. We have come on record. May I request for a date, my lord, that we can go through the matter and then submit, my lord.
Who was appearing?
Lord, one Mr. Srinidhi was appearing, my lord. He expired, so after which we have appeared, my lord.
You file some reply.
Yes,
You are for BBM.
I am for BBMP.
Learned counsel for BBMP. You have no role, man.
Lord,
The compliance report, my lord, 2 to 3 as per the directions of this honorable court. Lord, now all the local authorities are before my lords. So it will be easier for my lords to
My
issue direction.
responsibility is on Nagar.
BBMP, that is only for Bangalore.
only for Bangalore, my lord, but
My lord, other districts, my lord, they are represented, served but unrepresented.
Now, this act is of the year 1985. There is no upgradation, my lords, for the present situation. Therefore, my lords, a suo motu PAL was registered by your lordships. Then, my lords, High Court Legal Aid Services was directed to file a proper petition. That is how the present petition came to be filed. The prayers are, my lords, in consonance with the provisions of the Act itself. There is nothing new which has been added except the creating a web portal, my lords, and a citizen grievance mechanism under the Act. These are two things which your lordships have to consider. I will.
Bangalore Mahanagar Palika shall file reply for the next date put up on 25th November. 25th.
This number 57, Mr. G. Balaji Naidu.
26th or 20.
I appear to respondent number 5 and 6 in the first matter, my lord.
So in the second matter, respondents 1, 2, and 5.
I appear for 7 minutes.
I appear for the respondent number 4.
Which second, first matter, sir?
Lords, may I make one submission in this regard?
Yes.
Lords, recent developments, my lord, wherein the BBMP authorities have taken steps with regard to unauthorized construction. There are some notice has been issued to the BBMP, by the BBMP to the respondent over 8, my lord. This is Gale Gas Company. Those documents has to be placed before my lordship. I seek only one week accommodation, my lord. This matter pertains to unauthorized construction by the put up in the there is a civic community area. As per the CDP plan, there is a road is already existed, my lord. This prayer is page 18, my lord.
Team 3/2022 order may kindly be seen by this court. Pursuant to H 6/4/2022, certain orders have been passed.
I appeal for the petitioner in 57.1. I just filed Wakala today, I obtained the file yesterday. The lordship can grant me 1 week time.
May I submit this, my lords? I appear for the respondent number 7. I have taken a specific contention that the PIL is not maintainable because it's a petitioner's land. So his land was acquired, then it was given to the HMT Limited. From HMT Limited, it has been given to the respondent number 7. We are constructing a CNG station there. At that time, they come and file a PIL before this Honorable Court minutes. If it's his land, it's his personal interest. The PIL itself is not maintainable. That's a specific stand which I have taken.
They have sold it.
My lords, they have not sold it. It was acquired by the government.
Let
Hence,
them
PIL is not
land.
file already common rejoinder statement to the statement of objection, my lord. Wherein, my lord, their claim is that I am the owner to that extent, whatever I am claiming to the contention raised in the PIL is nothing to do with this land, my lord. I have given a detailed common rejoinder statement to the whatever my learned friend is making allegation against the petitioner is concerned. And to that extent, my lord, BBMP already have taken steps, and those documents has to be filed, my lord, before your lordship. I am seek only 1 week accommodation to file those documents, my lord. They already initiated the action against the 253 notice has been issued for unauthorized construction against the Gale Gas Company. Those documents has to be placed.
In fact, BBMP has to file those documents, my lord. I don't know why BBMP is not making any.
The request of learned counsel for the petition. And 22nd now.
Please, grateful.
Number 58. Sharath M.
Lords, I appear for the petitioners in these matters, my lords. We have filed a rejoinder in both the matters last week, my lords. It doesn't appear that they've been brought on record. A short date may be given. The pleadings are complete, my lords. Final arguments may be heard and the matter may be disposed, my lords.
We have not been served with rejoinder copies.
I'll ensure that happens, sir.
11 December.
I'm deeply obliged, my lords.
Yeah.
Number 59. Master RKGMM Mas Swamiji, 14%.
The respond.
My lords, supreme scale promotion has been denied arbitrarily, my lord, without stating reason in the original impugned resolution, my lord. It is not based on any evidence, my lord. Admittedly, selection grade promotion was granted based on ACRs, my lord. But while granting the supreme scale promotion, 5 judgments of 5 years, preceding 5 years was called, my lord. And it was gone through by the members of Honorable Promotion Committee. And they made adverse view as it is poor. And based by relaying the adverse view made by the decision-making power, it is denied, my lord. My lord, law governing the selection grade and supreme scale promotion, my lord, it is in the government order dated, my lord. It is at Annexure B, my lord, page number 140, my lord. Government order dated 22nd April 2006, my lord. My lord, in the preamble, the object of financial upgradation is mentioned, my lord. Chapter 17 of First National Judicial Pay Commission report contemplates ACP and financial scales to the judicial officers, my lord. The relevant part of report reads as follows, my lord. 17.6, my lord. It may be stated that ACP is intended to assure pay progress to officers within the time-bound scale, my lord. The scheme is designed to allow an officer pay upgradation when financial functional consideration don't permit promotion in the cadre hierarchy. The basic hypothesis here is that a person of considerable experience needs to be suitably rewarded to keep his tempo of work with high moral values and not to allowed to stagnate or degenerate, my lord. But my pay scale is stagnated, my lord, since it is not granted, my lord. My lord, further, 17.7, my lord, it is stated, my lord, the object. The commission has noted that there is lack of promotional opportunities to the judicial officers in view of limited number of posts. It is therefore necessary to provide them some form of in situ arrangements on a term-bound basis, my lord. It is time-bound promotion, my lord. My lord, the scheme is intended to afford reasonable opportunity to all the officers in the grade, my lord, to get financial upgradation in time-bound frame, my lord. My lord, this government order considered the All India Judges Association versus Union of India and other decisions also, my lord. My lord, further, my lord, after examining the relevant recommendations in consultation with the High Court of Karnataka, the government are pleased to issue the following orders, my lord. My lord, promotion criteria is contemplated, my lord, class 2, my lord, grant of financial promotions, my lord. A contemplates about the selection grade, my lord. The promotion criteria for selection grade and supreme scale both are one and the same, my lord. But the
year of seniority is only different, my lord. My lord, for supreme scale, my lord, it is contained at B, my lord, 10% of cared strength of district judges who have put in service not less than 3 years of continuous service in the cadre of district judge selection grade shall be eligible to be considered for promotion to the cadre of district judges supreme scale on merit cum seniority basis, my lord. My lord, merit cum seniority basis is already defined and ACR is assessed while granting the selection grade, my lord. When I was granting selection grade, supreme scale was also granted to two district judges who are 1.5 years junior district judges, and they were also granted on the basis of ACRs only, my lord. My lord, in the promotion criteria, my lord, there is no words as judicial performance and no word mentioned as assessment, my lord.
This appeal may be finally considered.
My lord,
We'll hear it at length. In that view, put upon.
please, my lord. Please, my lord. Please, my lord, short date.
Or this can wait.
There are decision, my lord. Coordinate bench decision is also there, my lord, for grant of supreme scale promotion. ACR only to be assessed, my lord.
While learned party in person, learned petitioner party in person was heard for some time, comma. He agreed that.
No, it is deferred, my lord. No supreme scale promotion is
he agreed
deferred, my
that
lord.
Petition needs final.
Honorable Supreme Court
petition-
has also
that
ordered
agreed
for
that
reconsideration, my lord.
He would made a detailed submission. In that view,
There is adverse,
let
it
it-
may be expunged, my lord.
in that view, let the appeal be heard finally. Put up in the week beginning from 9th December.
My lord, date, my lord.
In the week of 9th December.
My lord, a long date, my lord. Please, my lord. This month, my lord. Please. This month, my lord. Please, my lord.
Next
This month. This month, my lord.
This month is not possible.
Please, my lord. Please, my lord.
Final hearing will take up.
Please, my lord. Please, my lord.
So we come on
This month, last week, this month.
last week. Probably.
Please, my lord. Please, my lord.
On 29th December.
Please, my lord. Please, my lord. 29th November, my lord. Number. Please, my lord. Grateful, my lord. Grateful. There are decisions, my lord.
Filing of reply in contempt matters, number 60. Smita RV.
Objection. For some time he agreed for submission that that detailed submissions are necessary and that the appeal may be heard finally. In that we will put up on 29th.
I'm appearing for accusal number 1 to 5. Objections are ready, my lord. You will file it in the office.
7, 8. It is, what is the?
I have served a copy of the complaint on the objections on the council appearance. I have served the copy of the objections on the.
Disobedience of an interim order granted by the court.
Complied with.
No, madam, I have filed detailed objections, madam.
To file there, what is this, page 82 is the order?
1 to 5 have just now given me a copy of their reply. But 6 to 8 have not filed any reply. Your lordship may take that they have no reply to file.
6, 7, 8, we will file objection.
They have entered appearance long time ago, and these proceedings are being taken very lightly by the accused. Very lightly.
You want time?
Already.
You want time or you want? Time you want to proceed?
Let them file the statement. Your lordship, I will go through the complaint reply filed. Your lordship may fix a date, my lord.
Tell the date, learned senior counsel for the petitioners.
Complainant.
Request. Learned counsel, senior counsel for the petitioner requested for date. As per his request, 10 or 2.
Your lordship may fix the date.
Tell the date. Tell the date.
Any date you give. My lord, your lordship may give. Next week, my lord, or lordship.
Not possible. Next week is not possible.
My submission is your lordship may indicate the date, my lord, this month or next.
No. Either you proceed or seek date in the last week of November.
Last week of?
November.
Oh, very well, my lord.
Give the date.
27th, my lord.
61. Mr. Vasant Kumar came.
Hearing for the respondent statement.
Other side was to file the counter, my lord. 2-3 dates are already given. I do not.
My lord, this is an interim order against which
Maybe,
the contempt
but,
has been filed.
It's not that
again-
easy, my lord. According to me, my lord, this order has to be read in the final order which was passed earlier.
And this on.
And your lordships, while issuing notice, observed, my lord, the objections have to be filed, my lord. Anyway, I will be a submission, my lord.
The order
The
is passed.
interim order is at page 18, my lord, dated 11/9/2023. Now, basically, I would like to place this previous order of this honorable court, my lord.
Sanjay Gowda order.
This is the second writ petition against which the contempt has been filed over an interim order. But before that, there was a writ petition filed by the complainants. I would like to just take your lordships through that order, which is reflected in the interim order.
That's what I also wanted to submit.
12966 is the writ petition, previous.
This contempt is filed by whom?
My lord, by a person, my lord, who belong, my lord, to whom the land belongs. But the authorities say, my lord, it is a forest land. Regarding that, my lord, earlier writ
They are
petition was
party in the
filed.
main proceeding.
Who, my lord?
Those
Please,
who are-
please, they are. They are party. My lord, just for a moment, if your lordship.
Kindly see
visit
the
the
earlier,
complete-
that's what I also wanted. So earlier, there was an order, my lord, final order. That order has to be read, my lord, along with this interim order in the submission. Therefore, they are bound to file the counter, of course, subject to what my friend would say.
And this honorable court with regard to interim orders has already dealt, saying that it has to be,
What is
May I pass on?
this is
Earlier
the,
order, this was there. Two
Which,
writs.
which earlier order?
So the earlier
Which-
order passed by this, my lord, by the, my lord, single judge. That has to be read in continuation of the interim order in the submission.
We do not.
the interim order reflects the, I-
In the earlier round, my lord, very same party petitioner had filed a petition, my lord, there was a lot of galata and all that. My lord, page 6, my lord, para 13. Page 6, para 13, it is the operative portion. The lordship gets that, my lord. Para 13, my lord, page 6.
We are not inclined. There is no gainsaying.
Lots.
You know, interim order, we are not.
No, interim order, your lordship's order, if I am permitted, say, my lord. Now it is no longer good law, my lords. Supreme Court has already, Amit Kumar's case recently has held, my lord, that interim order can be looked into, provided it, my lord, it affects the parties.
circumstance. there
And my
is
lord,
different.
order passed by your lordship, my lord, has already been called, my lord, the Supreme Court matter has been stayed, my lord. Lordship would recollect, my lord. That is also there. One semester. Secondly, my lords, very interesting aspect is, kindly see, my lord, the order they have passed on.
Which
Order
order
that
you are
was passed.
relying?
Which one? Earlier order, my lord, it was passed, my lord. That is a continuation of this is my submission.
No, you said that interim order, Supreme Court, which is that?
There is an order by my lord party before, but he was a contemptor here. But this honorable court, the honorable Supreme Court has, in those proceedings, my lord, your lordship said. Ide. Of course, my lord, regarding maintainability, I am very well, my lord, I can urge, my lord, before that, my lord, my submission is, let the order be seen how it is, my lord. Or let the first order of this honorable court has to be seen, my lord. That's what I'm making submission. Kindly see, my lord, for a 2 minutes, my lord, virtually to amount, my lord, regularly, I'll be able to demonstrate, my lord. My lord, page 6, para 13.
of the earlier order I passed on, my lords. Kindly see, my lord, that will reflect, well, the whole thing depends upon that, my lord. Para 30, may I read, my lord? Yes. The authority is, my lord, para 13. This is what has led, my lord, to para 13, my lord, space 6, my lord. The authorities cannot unilaterally assume that the petitioner has accepted his land is situated within the forest area. In fact, the map of Srinivasapura forest which is produced indicates that there have been encroachments over several extents of lands or several survey numbers, and thus unless the basic question as to in which survey number the area of 4,660 acres are complied with, it would be improper for the forest department to unilaterally assume that its land has been encroached upon. In that view of the matter, impugned orders are set aside. However, liberty is reserved to the forest department to conduct a survey to demarcate approximately 4,060 acres, which was notified as Srinivasapura forest land and notification dated so and so. If no such survey is found, then there have been encroachments. It would be open to the forest department to initiate the appropriate action against that. This was the earlier order passed. Thereafter, my lord, without doing this exercise, my lord, the authorities went on again. They say, but they came to my lands, my lord, they encroached my land, they destroyed the, my lord, crops, my lord. Then I filed the present writ petition, my lord. In this writ petition, there is an order passed, my lord, that which is now, my lord, before lordship, my lord, page 18 of the papers, content papers. May I read, my lord? Learned government advocates directed to take notice of all the respondents. Learned counsel the petitioner directed to serve a copy of the writ petition, so and so. Learned senior counsel, so and so, appearing for the petitioner, submits that earlier the petitioners were before this court in WP number so and so, complaining that the respondent deputy conservator of forest Kolar has passed the orders of eviction against the petitioner, although the land was granted by the revenue authorities. My lord, revenue authority documents are very much there, my lord. This court, by the order dated 17/4/2023, set aside the order impugned therein and reserved liberty to the forest officials to conduct a survey to demarcate the approximate area of 4,660 acres, which were notified as Srinivasapura forest land under notification dated so and so. And if it is found that the petitioner encroached upon any part of the reserved forest, action can be taken. However, very important, however, the survey was required to be conducted in the presence of the parties while giving opportunity of hearing. Learned senior counsel submits that without passing any orders and without even issuing notice to the petitioner, the forest department authorities have entered upon the lands of the petitioner, demolished the structures, destroyed the crops. Authorities have not even given a copy of any order if it has been passed by the competent authority. Learned senior counsel would submit that under similar circumstances, this court in WP number so and so gave interim protection to the petitioner therein, directing the respondent not to disturb the position of the petitioner so and so, learned so and so. Consequently, respondent authorities, more particularly the forest officials, are hereby directed not to dispose of the petitioner and not to disturb the peaceful position of and not to enter upon land in question till the, with all this, my lord, they register a criminal case against me, my lord. FIR is lodged against me, my lord. And my lord, page 33, page 35, page 38. My lord, unless they find, my lord, they make a survey, my lord, they have got to issue, pass an order. What area is covered, my lord, what is encroached upon. Without doing that, FIR is registered. They enter upon my land, they throw me out, but they have, my lord, my situation, my lord, lakhs of rupees, my lord, crops grown by me have. Therefore, enduring, there is one aspect. Regarding question of interim order, your lordship knows, my lord, latest Supreme Court, my lord, has already held, my lord, in Calcutta case, my lord, Amit Kumar Das case. Supreme Court has said, my lord, even if it is an interim order, if, my lord, the parties are not able to demonstrate with lordship, my lord, if they really, my lord, a contemptuous act goes on till date, this honorable court will take action, my lord. Latest, my lord. Therefore, my endure is, no, my lord, knowing all this, my lord, on the face of it, my lord, even now they are, my lord, they are not permitting you enter my own land. My lord, who identify my land to be forest land? Therefore, my endure is, my endure is only, my lord, let them file the counter. You will ask to be here, madam. If you ask are satisfied by the way, my lord, they do it, my lord, I will be glad, my lord, I will take the order.
My lord, I have.
This is not one day, my lord. It's not first day, or my lord, these things are going on. Let her file the counter, my lord. Let her, my lord, demonstrate and say that I am wrong, my lord. I will for a minute, my petition would not lie, my lord.
My lord, if the senior counsel has finished, I would like to make some submissions with regard to this case. My lord, as the senior counsel has already mentioned, this interim order emanates from the earlier writ petition, round of writ petition, which the learned senior counsel read. Now, in that, my lord, if I take your lordship through the from the beginning of the order, this was with regard to an order of the deputy conservator of forest for eviction was challenged in the previous round of the writ petition. Now, over there, what happened is the notification of this area comprising of a total extent of 4,000 odd acres has been notified by
My endeavor is let them file counter, will ultimately decide the whole issue, my lord.
My lord, I have only two submissions. If your lordship may kindly permit me to make my submissions, my lord. My lord, if I just take your lordships through the earlier order, which was placed before your lordship, this was, what happened is over here, the issue of whether it is forest land or revenue land for the larger extent of 4,000 acres, which comprises of revenue and which comprises of forest, and where does the complainant's land figure, whether it figures in the revenue or the forest was to be determined. And therefore, the order comes, was to conduct a joint survey, my lord. And if we read 14, para 14 of that order, however, liberty is reserved for to the forest department to conduct a survey to demarcate the approximate area of 4,600 acres.
Which order?
The previous, which the learned senior counsel put forth, my lord.
Yes.
The writ petition 12966.
Yes.
This writ petition challenged the DCF order of eviction in 2008. While hearing and deciding this case, the learned single judge looked into the aspect of a joint survey needs to be conducted to determine as to where the complainant's land falls, whether it falls under revenue land or whether it falls under reserve forest land. Now, para 14 of the order, my lord, however, liberty is reserved to the forest department to conduct a survey to demarcate approximate area of 4,660 acres, which was notified in Srinivaspura State Forest under notification, and the notification dated, my lord, is actually of 1910, 1910. If on such survey, it is found there has been an encroachment, it is open to the forest department to initiate appropriate action against the encroachers. Now, pursuant to this order, my instructions are that notice as per Rule 69 of the Karnataka Forest Act was issued on 27/7/23. Pursuant to that, joint survey was called of all the parties, stakeholders.
State all these on affidavit.
Please, my lord.
All these facts you state on affidavit.
Please, my lord, and this is an interim order, and therefore into merits, it can't be gone into. And this being a forest area, it's a Godavarman decision falls
Which
strong.
proceedings are taken out, you are saying?
Please, my lord,
Which notice is issued?
which
Proceedings.
You say some notice is issued.
notice under the Karnataka Forest Act, after this order, my lord, the first writ petition, in compliance with the Karnataka Forest Act and rules, we have proceeded.
All that.
But after that, they again go before the
Place all that on that side.
They again approached the learned single judge. And in fact, the order, my lord, that there was no notice and all issued is incorrect.
My lord, my only submission, of course, unless, my lord, if it is put by way of counter, my lord, that I
I
think your
will
lordship would
have
decide the only.
these facts placed
Because,
on
my lord,
record.
even your
I
lordship's
have
earlier
the
order,
facts
lords.
Based on record, my lord. Notice has been served.
Let her
Petitioner's
find
signature also has been taken
Do it.
during the Mahazar.
When will do?
Last week of November, my lord,
26th now.
please.
Date.
Much obliged.
Last week of November. Very-
Number 62, the KV Narasimhan. 62, I'm filing an affidavit. 62.
Not there.
My lord, the representation has been considered, my lord, and an endorsement has been issued here.
Learned additional government advocate, Mr. Harish stated that the representation is considered and the encroachment is issued. And that in that view, the directions of learned single judge are complied with. Full stop. Having noted the above submission, since learned advocate for the petitioner is not present, the petition may be listed on 7th of November at 2:30.
Number 63, the Manisha Kongovi.
Here for the complainant, my lords, the respondents are yet to comply with the order of the learned single judge, my lords, directing them to extend the UGC payments to me, my lords. UGC wages, they are still yet to comply, my lords, respondents.
You complied with.
No, not yet complied, my lords, not yet filed
Writ appeal
objections.
filed, my lord. Writ appeal in 1374 of 2024 has
So
been filed.
stated by learned additional government advocate that the
Sir,
writ
copies
appeal
of
is
my-
filed in respect of the orders under contempt. In that view,
I have not received a copy yet, my lords.
with writ appeal number
1374 of 2024.
374 of 224. 1374.
74, my lord.
37, all right, yes.
Number 64, ready notice matters. Manu Prabhakar Kulkarni.
Advocate in this matter, my lords, may I request
Yeah, for respondent
matter
too,
to
my
have
lord.
next week, my lords.
4th December,
Please, ma'am.
as requested by learned advocate, it's not stand over to 4th December.
Number 65.
And for the petitioner. But petitioner is seeking direction against the authorities to consider his application produced at annexure B for execution of quarrying lease in his favor. Petitioner had filed his application on 20th October 2014 and which is not yet considered and disposed of. Not pursuant to his application, both NOCs as required under Rule 8, Sub-Rule 5 issued, which are at annexure C and D. And later on, notification is issued, grant notification, that is annexure E, page number 41, under which sanction is given to execute the quarrying lease. And after that, I have obtained environment clearance certificate and quarrying license, quarrying plan and all that. Even now, the petitioner's application is not disposed of. Not recently, on 28th October 2020, annexure G.
Seek some accommodation, my lord. Weeks accommodation. I seek a week's accommodation in the matter, my lord.
Consider.
For mandamus, my lord, for consideration of their representation.
You
Relief of
decide-
mandamus being sought.
You decide whatever you want to, you don't decide.
Very well, leave to your lordship. Very well.
Hard learned advocate so and so for the petitioner and learned additional government advocate Mr. Harish for the respondent who appeared upon service of the copy of the petition in advance. The case of the petitioner is that he has applied for grant of 4 release in the year 2014 for extracting the ordinary building stone. The quarry lease is applied in part of survey number 613, head measuring 4 acres. Situated at Sattigiri village, Yaragatti Taluka, Belgavi district. Land is a government Gaya-Rana land. Further case of the petitioner that the petitioner has complied with the mandatory conditions and observe the formalities under the Karnataka Minor Mineral Concession Rules 1994. Despite this, the application has not been processed and no decision is taken. Wherever, on the basis of the above basic premise, the basis of the above facts premised, above premise of facts, the prayer is made to direct respondent authorities to consider application to the 15/20, 2014 under the KMMC rules 2023 for grant of release. Since the petition is pending since 2014 and has remained undecided, since the application is pending since 2014, since the application of the petitioner is pending since 2014 and has remained undecided, and the only prayer is on, and the only prayer made is to direct the respondents to consider the said application, this petition could be disposed of by directing the competent authority of the respondents to decide the said application petition strictly in accordance with law and decide as to whether the petitioner is entitled to grant of release. It is for this court has not gone into merits, nor has expressed any opinion on merits. First, it is for the competent respondent authorities to go into the issue in accordance with the rules and to take its own decision. The petition is disposed of accordingly.
So time limit may be some.
On decision, preferably within a period of 12 weeks.
Number 66. Are they with them?
My lord, for the petition of this matter, my lord,
We have for respondent number 5 and 6, my lords.
it's a PIL. This is an instance of encroachment of a stormwater drain. And there's a construction, my lord, page 56. I've produced photographs of the constructions on a stormwater drain, as a result of which the entire area is suffering from flooding. The stormwater drains which connect two lakes, the respondent 6 and 7 have constructed buildings upon these stormwater drains and which have almost completed right now. My lord, page 56 and to 59, I've produced all the photographs. My lord, there is a report by the village accountant. May I take, my lord, to the report wherein unequivocally they have, my lord, noticed the encroachment on the part of the respondents. May I take, my lord, to the report, page 95. Page number 95 is the translated portion of the report submitted by the village accountant. My lord, the third line, the fourth line from the top, my lord. In survey number 112/1, 2 acres, 3 guntas of kharab land, the encroachers so-and-so and his brother so-and-so have encroached the Rajkalwe or stormwater drain and have got constructed a rest houses, basically commercial complexes, car repair garage, service station, and the Taluk surveyor has submitted encroachment sketch after conducting a survey-wide letter dated so-and-so. The Taluk surveyor has submitted the sketch and report stating that so-and-so have encroached the lands as shown in blocks number 1, 2, and 1 to 5. Produced in this regard, so-and-so, these are the respondents 6 and 7, my lord, are not holding any khata and pahani in survey number 112/1. In spite of this, it is found that they have got constructed commercial complexes and rest houses. My lord, thereafter, the Tahsildar also has passed a report, page 109, has also submitted a report. The Deputy Tahsildar's report is at, say, page number 109. My lord, may kindly see page 109 is the last line, my lord. I will not bother my lord with the other details, peruse the same as per the report, that is the last line, as per the page 110, my lord. As per the report of the revenue inspector and the village accountant, the respondent 6 and 7, these are Jairam and Keshav Gowda, residents of so-and-so have illegally encroached the Rajkalwe and the government road running through survey numbers 112/1 and have got constructed a building and are ready to use it for commercial purposes as found from the sketch and the report submitted by the surveyor and the report. After this, even the Tahsildar has submitted a report at page number 113. Despite all of this, all of these reports have been submitted to the respondent number 2 deputy commissioner. But no action has been taken, my lord. Construction is still ongoing. As a matter of fact, they have observed that no conversion also has been obtained insofar as these lands are concerned. Till date, no action has been taken. My lord, the government is for the respondents 1 to 5, 1 to 4.
Inconvenience to Madam Nilofer Akbar, my lord. Kindly have it next week, my lord.
This 5 and 6 are represented and
At the request of learned additional government advocate, Mr. Harish, stand out. 21st November.
Or may I request for 2:30, my lord, the matter may be taken up at 2:30, my lord. Very grateful.
Number 67. Chal Pradeep Kumar.
For the respondents only.
My lord, representing Pradeep Kumar, advocate Pradeep Kumar, my lord. He isn't feeling well, requesting a week. Pardon? He isn't feeling well, my lord.
Who is not?
HL Pradeep Kumar, advocate.
Pradeep Kumar.
He isn't feeling well.
Who?
Advocate, my lord. My senior advocate. He isn't feeling well.
Not feeling well because of this
Requesting
matter.
Sir, my lord.
At the request of learned advocate petitioner, stand out to 6th December.
This is number 68.
Number 68, my lord, I appear for respondent 1 2. We have filed one more writ appeal, is what Mr. Chandrasekhar informed me. Same order challenge.
Right. Writ appeal 817.
Writ appeal 817 of 2024 has been filed by.
I have filed one more writ appeal.
Who appears for the KADB. I represent the BMRCL. We are in appeal in the present writ appeal. The same order has been challenged by the KADB also. Requested even that matter be tagged along with this matter. Writ appeal 817.
817. To be heard with.
To be heard along.
To be heard with writ appeal number 817 of 2024.
817.
This is number 69. Mr. Mahesh Chandra PN.
Lords, I appear for the appellant, my lords. There is a delay of 41 days in filing the present writ appeal, my lords.
142 days. Notice already issued.
They have filed wakalat, my lords. The private respondent has filed wakalat, my lords. They were.
Who appears?
Private respondent. Let him serve a copy upon me, but I don't have a copy of the writ appeal as well.
Serve copies, 7th December.
Lords, an earlier date, my lords. An earlier date, my lords. For the reason, my lords, he is an employee of B group, my lords. He is sitting in a place of C group and he is a specially skilled employee of.
You supply copy first. Yes.
Kindly.
70.
Send out to 7th December. In the meantime, copies shall be exchanged. Copies of the pleadings shall be exchanged.
70 urgent. Number 71. Mr. Krishnappa NR.
Delay may be condoned, my lord. Kindly have it next week, my lord. Kindly have it next week, my lord. Delay is there. Delay may be condoned. Delay. 62 days.
Delay.
See.
Why should we condone? What is the delay? 62 days.
Next week, kindly.
Next week. At the request of learned advocate for the petitioner, stand out to 7th December. Not 7th December, 10th December. Whom I is prayed for. Next.
Much obliged.
This is number 72. Rajendra Kumar Shinge.
I appeal for respondent number 1 in this case.
Appeal for respondent number 2, my lord, for UGC. Kindly pray for short accommodation for
The instruction to
At
UGC.
the request made by learned review for respondent to stand over to 11th December.
Interim order may kindly be extended. There is an interim order, it may kindly be extended.
What entry mode? Like, no entry mode.
So cost of, my lord, 10,000 rupees, my lord, compensation was awarded, 10 lakhs.
This is appeal. Why you are seeking? Why you are seeking time? We are not granting time.
My lord, sir, kindly take instruction for UGC, my lord.
Hmm?
Take instruction of UGC.
Along with the petition, my lord, the learned single judge has directed to pay 10 lakh rupees, my lord, as a compensation. Though, my lord, there is no prior, my lord, in the writ petition and only that part, my lord, has been stayed, my lord.
Why compensate? You are for petitioner.
For UGC, ma'am.
UGC.
Yes, ma'am.
Then why you are seeking time? And the petition is by whom?
Petition is by the university, my lord.
Appeal heard learned advocate for the appellant, Mr. So and so, so and so. Appeal is admitted. The impugned judgment and order shall remain in state. Appeal may be listed for final hearing in the week beginning from 16th December 2020. Already granted.
Yes, my lord, it's already granted. May extend it.
Interim order shall stand extended. Appeal is admitted to be listed for final hearing in the week beginning from 16th December. Interim order already granted shall continue to operate.
Much. Much.
Yes. So number 73, so B.R. Vishwanath.
Correct. My lord, the learned judge relying on probate proceedings, my lord, upholds the right of the first defendant for mutation of revenue entries. Although the civil rights have been decided in earlier original site proceedings, my lord, based on a probate and success proceedings, my lord, the revenue entries have been ordered to be mutated in favor of the first respondent. That too, my lord, in respect of a property which has already come into the jurisdiction of BBMP 2 decades ago, my lord. The earlier civil proceedings, the first respondent was also a party, my lord. He has not challenged it. The title was upheld. The permanent injunction was granted in respect of the subject property in favor of the appellant. But subsequently, my lord, suppressing the said fact, and a will is created by a person, my lord, who was not at all competent to execute such a will, and probate is obtained. Based on that, my lord, the impugned order judgment, I request your lordship to kindly peruse the judgment passed by the learned single judgment.
But this survey number is within jurisdiction of BBMP.
BBMP,
That will not change the status of ownership.
since 2 decades, since more than 2 decades, my lord, the question of mutating revenue entry in respect of a property which is already situated within the BBMP limits, my lord, was totally redundant. To create confusion and also to create certain documents, subsequently what they do is, my lord, in pursuance of the revenue entry, they will go to the BBMP and try to get the kata registered in their name, suppressing all these transactions.
So entry will be recorded by which authority?
Yes, my lord.
Entries will be recorded by which authority?
By respondent number 3 and 4, please, my lord. That's the government revenue authorities, please, my lord.
3 and 4.
Please, my lord, the Tahsildar and
And what was the prayer in the petition?
please, my lord. Before the learned single judge, please, my lord, the order of the assistant commissioner and the deputy commissioner
Then
were
you are-
challenged.
You are supporting the appellant.
Plus,
Who is contesting this one?
I am the contesting respondent.
Contesting.
I appear for respondent number 1.
The mutation of revenue entry was challenged before the assistant commissioner by this appellant, my lord. So that revenue entry in pursuance of a probate was cancelled and my appeal was allowed by the learned assistant commissioner. The deputy commissioner, my lord, reverses the, also supports that. And subsequently a writ petition was filed. But the learned single judge, my lord, on the basis of a probate granted in respect of the property, my lord, set aside the order of the deputy commissioner and the assistant commissioner, and the revenue entries are restored, my lord.
We'll consider on 11th. Given for it.
Interim order.
Interim orders is there.
No, my lord, it has to.
We'll consider the matter on 11th.
Obliged.
Yeah.
Number 74 to Som Sundar Rao. Number 74 to Som Sundar Rao.
Let it go to December. 6th December.
75 agents, number 76. Vivek Ulla.
For the respondent. We are trying to settle the matter.
You are Mr.
2 weeks of.
My lords, I appear for the appellant, my lords.
What is your name?
Naman, my lords.
You are for appellant. So he is right.
Yes, my lords.
Shall we record or simply adjourn?
My lords may record it also. No.
Learned counsel the parties state that the parties are engaged in the settlement process. In that view, they seek time, stand over to which date?
2 weeks of time.
2 weeks. 5th of December.
Great. Interim order may be extended.
Interim order already operating shall continue.
Great.
For it till the next date.
Great.
Number 77.
Stay
Mr.
for the
Narasimha K.
complainant. Lord, the complainant has filed a writ petition seeking direction to the Tahsildar.
Yes,
So-
what is the?
We have filed our compliance, my lord, dated 19th June 2024.
Lord, the paragraph 5 at page 3 of the complaints affidavit. They say, my lord, that this land has been acquired. My lord, without entering my name in the records of rights. My lord, I am not entitled to seek for a compensation. But my lord, they say I am entitled for a compensation on the basis of the letter. They read, my lord, paragraph 5 of the complaints affidavit at page 3. I respectfully submit that the mutation entries to be effected are sought only for purpose of obtaining the compensation, and accordingly a letter of confirmation of their rights and title is issued by this honorable authority, so that by placing the same before the land acquisition officer, the complainant can obtain the compensation. Copy of the said letter is produced herewith and marked as Exhibit R2. My lord, Exhibit R2 at page 11, my lord, English translated copy. My lord, my lordship may kindly turn to ink page 13, my lord. In this, my lord, the authority they have given only
Any endorsement or order is passed?
Please, an endorsement dated 18/3/23 and then subsequently
N6. N6.
my lord,
Endorsement.
annexure R1 at ink page 6, my lord.
R1, my lord, and
Ink page 6.
R1.
R1, my lord, increase.
Dated 18/3/23.
18/3/20.
Yes, ma'am. They say the sanction is correct to the Dasagoda, that is the husband of the complainant. But my lord, unless there is a mutation proceedings and my name is mentioned in the records of rights, my lord, I cannot able to get the compensation from the land acquisition officer.
Hence, you are hereby informed to submit your grant and sanction documents such as the Sagoli chit, OM and sketch as per the rules, and other necessary document to the special land acquisition officer to obtain the compensation.
So it is.
And then we have also
What you have decided?
issued a letter.
You decide, you have to consider the request of the petitioner for entering the name in the revenue record. Now, how far, what is about compensation? How can you misdirected yourself?
My lord, let me look, I'll look into these.
There is
papers and,
something,
I'll
officer
look
has not well directed himself.
Let
and
me look into
decided.
these papers and,
Learned additional, learned government editor. Shweta Krishnappa, 6 times. Send over to 14th November,
my lord, I'll be
little longer,
last week of
last week,
November.
26th of November.
Please.
Number 78, A.D. Ramana.
Lordship, complaint by me.
For the respondent, my
The
lord,
learned
to
single.
comply the complaint affidavit also filed before this court, my lord.
Hmm.
Comply the order, my lord, and file the complaints affidavit.
Your Lordship,
For
there
this
is
court.
the incompliance affidavit filed by the accused. Your Lordship, the case of the complainant was, our job should be regularized and an arrears of 1.18 crore should be given. They have paid, deposited without notification. How they deposited only 24 lakh part complaints. Earlier to this, I have filed 2 memos. And first memo on 27/11/2023.
Who is to comply with the direction? Who will be complying with the direction?
As third respond, management, my lord.
Management.
School management, my lord. As per representation, my lord, salary given by the 34 lakhs, my lord. As per my request, my lord. As per the pass by this honorable single bench, my lord,
You have decided, reconsider the representation or not?
considered, my lord. Considered.
That order.
File the affidavit, complaints affidavit filed on 22/2/2024 filed before this court. my lord.
22 to 24 years.
Endorsement given by the complaint and along with affidavit.
It is rejected.
My lord.
It is rejected again.
They've given in part, my
Consider
lord.
the order.
They have actually submitted certain amounts of money.
So nothing survives, man.
Your Lordship, it is not like that. Your Lordship, my arrears is 1.18 crore. And there are 2 parts of the judgment. One is I should be regularized in the aided institution. They have filed a false affidavit saying that I joined as in unaided institution.
That is not we are concerned. We are not in a writ petition.
No, Your Lordship, then my liberty may be reserved because again, it will be one more litigation. Your Lordship, what happens is the institution, if they try to get away with the order but against my total payment of 1.18 crore, I have filed my statement of objection. I given them what 24 lakhs, how they have paid. They have not given any memo of calculation. They have just deposited the part of amount. I have given the entire calculation how I should get 1.18 crore because from 2012 I was paid an ordinary job, citing reason that I had not completed my this thing. My representation is not considered fully, and it is not been. They ignored the order. Your Lordship may kindly turn to the memo dated 27/11/2003. Even after issuance of notice, contempt notice, they give a endorsement saying that you are not entitled even for 3,000 rupees salary. Then I gave my actual salary. I was employed. in aided institution and I was paid 38,000 and odd. Suddenly they reduced my salary to 20,000, saying that you have not completed your post-graduation thing. That was quashed, that what endorsement they have given is wrong endorsement. So I filed a writ petition seeking to reinitiate, to regularize my job and also to pay back my arrears from 2012. So part 124 lakhs is very meager amount against 1 crore 18 lakhs what I have given my representation. So if the respondent tried to avoid this payment, it will be one more. From 2012, I have been a sufferer. Your Lordship may kindly consider that I should have, my job should have been regularized in year 2012, where for 3 months I was getting aided institution job. Now suddenly they file an affidavit that I had joined the unaided institution. It is totally against their own. I have produced the document where I got the AICT salary. And now they say that you're joined in an unaided institution. If this is the case, if this kind of affidavit is being filed, the prejudice will be against the complainant. She has to undergo one more. The judgment say of the learned single judge is to my petition before the learned single judge was to regularize my job and also pay the arrears of salary from 2012. And as per my calculation, it should be 1 crore 18 lakhs. They have paid 24 lakhs. And earlier they said only around 30,000 or something it should be given. The manner in which they are dodging this, Your Lordship may kindly look at my statement of objection and consider if this kind of part complaints is made, then the justice will be there. Already I have suffered from 2012. I have only 6 more years of service. If I would be entitled for pension and I should be in government aided institution, not in unaided institution as the affidavit they have filed. Nothing they have given any, they have just stated that I worked in unaided institution. They are not given any document to support except mere affidavit saying that I joined in an unaided institution. They are not given any document. Whereas I have produced in my statement of objection to their memo that I worked in the government aided institution and they have given salary as per the government aided institution in 2012. After giving 3 months salary, they have stopped that salary and they have given the unaided salary. No issue.
That is all.
That's all.
Learned single judge in his order dated 13th March 2023 directed the respondent number 3 and 4 to reconsider the representation dated 9th March 2021 submitted by the petitioner. Full stop. In response to the present contempt petition.
I had given represented by Annexure F. My representation is by Annexure F, which is not been considered.
Compliance affidavit came to be filed by the respondents. Full stop. Learned advocate Mr. So-and-so, learned additional government advocate Srimati Miss Sweta Krishnappa for respondent 1 and 2 and learned advocate Ms. So-and-so for respondent 3 and 4 pointed out from the compliance affidavit that endorsement within 19 to 24 has been received and the representation has been reconsidered and decided. Full stop. The court is not concerned with the merits of the decision. Full stop. Since the representation is reconsidered and decided, on the directions of learned single judge are complied with, no contempt is committed. No contempt can be said to be committed. The proceedings are closed. We have learned advocate for the petitioner as complainant would request that liberty may be reserved for the petitioner to challenge the said endorsement on merits. Full stop. Said endorsement. Full stop. Such liberty is reserved. The petitioner. It is open for the petitioner to challenge this decision in an independent proceedings for which this court does not express any opinion on merits.
Much obliged.
Next.
Number 79. Eternally Varsha.
Nobody is there, then it will go to 16th December.
Cell number 80 to S. Shivaprasad.
Complaint. Endorsement received. Contempt case may be closed.
Pardon?
Endorsement received.
Received. Learned advocate, Mr. S. Prasad stated that the endorsement is issued and therefore the direction of learned single is complied with. Full stop. Dismissed as not surviving. Learned Beachman, learned additional government advocate, Ms. Sweta Krishnappa confirms the statement of complaint.
Considered.
Cell number 81 to Yogana KP.
Number 1, 2, and 5, man.
Which was that? 80. 80 is disposed?
80.
80 is disposed.
Now 81
2 weeks time.
Yogana KP.
Compliance office objection. 2 weeks time may be granted.
Pardon?
2 weeks time may be granted to
2 weeks
complain.
time. 10th December, as requested by learned advocate for the response. Office objection will be complied with petition before the next date. Link with the contempt petition shall stand automatically dismissed without reference to or order of the court.
Cell number 82.
It okay for the complainant in this matter, my lord. My lord, I have filed a memo to substitute the name of the present incumbent. Previous incumbent has demitted the office. I have submitted a memo on 2110, my lord, and fresh PF I will be taking. Process, I will be taking a fresh one.
No, you seek amendment, memo will not do. File amendment application.
Please, my lord, a week's time, I kindly.
Week's time. 20th November.
Much of.
Number 83 issue Vijay Kumar SC.
There is for complaint. They have filed affidavit. And they have filed
Statement of
affidavit
objection. Next week.
stating that they have not made any disobedience of the order. But they have, what happened is, a suit is filed for partition and partition. In the said suit, the respondents herein are the defendants. They filed a counterclaim. Suit is dismissed. Against that, the respondents filed appeal. Appeal was allowed and they were declared as owners of the land in question. That land was purchased by me. I being agreed by the order of the first appellate court, I filed second appeal before this honorable court within the limitation period. And I obtained the interim order. He has also appeared in the said proceeding, and after hearing him only, interim order was granted. In spite of interim order, entries were effected in his name. He has knowing that he has interim order is granted by the honorable court. He has not withdrawn his application for effecting kata in his name.
I filed the statement of objection next week.
First, they have filed.
Filed a statement of objection. I filed statement of objection already. Next week we'll go through papers.
What is this content? Page 23. 20, order admit following this, which order is under contempt? Order denied.
Order dated 14th December 2020.
Read I am the view. Read what is it? I am of the view that appellants are entitled to some protection.
Please.
Read it.
Page number 21. Orders on I-1/21. Since the captioned appeal is admitted, I am of the view that the appellants are entitled for some protection on examination of material on record, more particularly the admission
So
elicited.
you file contempt against which direction?
Please.
You filed this contempt petition in respect of which direction?
Interim order is granted, interim order staying the operation of the order passed by the first appellate court.
Where is that?
Please. Admission elicited in cross-examination of DW2, it is clearly evident that the defendant number 1 pursuant to the partition was found to be in possession. Defendant number 1 who claims to be the southern portion having 2 acres 36 quintals allotted to his share has sold in favor of the defendant number 6 and 7.
Admittedly, this contempt petition is filed in respect of order. This contempt petition is filed in respect of order dated, which is the date?
14 December 2023.
14 December 2023. It is admittedly an interim order passed in the regular second appeal. Full stop. The second appeal is pending, paragraph. The
Your Worship,
second-
by virtue of the entries in the record, they are going to take the loans on the land by
Rights of
producing
the
the
party-
documents.
Rights of the parties are not finally crystallized. In that view, the court is not inclined to entertain the contempt petition by exercising the jurisdiction.
I may be permitted to leave liberty to the complaints to challenge the order of the entries made in the name of the respondents.
Withdrawing,
Please.
withdrawing.
Well, liberty may be given to the complaints for challenging the order of the
Not
estate.
inclined to entertain the contempt petition and not willing to exercise the jurisdiction under the contempt of courts of 1971. Not only that, the petitioner has a remedy under order 39 row 2 capital A of the Code of Civil Procedure 1908. Such remedy may be availed if advised in accordance with law. With such observation and without going into the merits, the petition is dismissed.
84, Mr. K. Sridhar.
I appear for the petition complainant.
What is it?
Instruct direction issued at page number 14, my lord, para 6 of the order of the learned single judge. Para 6 and 8. Then, my lord, now they have filed a complaints saying that we decided not to make follow this judgment because we have decided not to make any recruitment. That submission cannot be allowed because they have not gone before the learned single judge to seek modification of this order.
Amendment was proposed.
My lord, amendment was proposed, my lord.
Then what happened?
In the meanwhile, my lord, the National Nursing and Midwifery Commission Act 2023 was notified by the central government, my lord. That statute provides for formation of a state level commission, my lord, which will go into the question of recruitment and other procedures, my lord. In the light of the act being notified, my lord,
Where is your, where is
Lord,
your?
the
Yes.
statement of objections filed on 23rd September 2024 may kindly be seen, my lord. Annexure R1 is the National Nursing and Midwifery Commissions Act, my lord, that was notified by the central government. The proposed amendment was sent to the National Nursing Council, my lord, for opinion. They have opined, my lord, it may not be necessary in view of this statute coming into the force, my lord. In the
My
light
lord-
of the statute coming into the force, my lord, the amendment may not be necessary. That is the opinion of the National Nursing Council.
My lord, that notification was even before the judgment of the learned single judge. They have, in spite of that notification of the year 23, they give an undertaking that they will do it, my lord. And it is not the first time this direction has been issued. Earlier also, in another writ petition, judgment direction have been issued. This is the second time this direction has been issued. The first time this judgment, kindly see the first time issued in another writ petition. This defense may not be available because that notification was available even before the learned single judge has passed the order. In spite of it, they said that, oh, no, we for the Karnataka, we wanted to do it. But they don't want to do it. But they have not gone before the learned single judge, either modification of this order or seeking clarification. That would be the proper forum for them, my lord. The learned judge should have decided that matter. The earlier judgment also is there, my lord. Same direction have been issued. Now they are playing hide and seek. My lord, now they have made appointment of a ad hoc person and they don't want to make a regular recruitment. They have issued a notification earlier. They have withdrawn it and given undertaking that they will do it. Now they say because of 23 notification, we will not do it. That 23 notification was available even when learned single judge has passed this order.
In this contempt petition, it is in the respect of the following directions of learned single judge in his order dated 14th December 23, found in paragraph 8 of the order, that the contempt is alleged, and court page, bracketed portion, page 15, paragraph 8. However, we start from however in 2 months thereafter. So in response to the notice issued in this petition, from a compliance affidavit came to be filed by the in-charge principal secretary, in-charge principal secretary, Department of Medical Education of the state government, in which it is stated in paragraph 4 thus: and as per the aforesaid directions, court bracketed portion, which has come into effect. Then after quoting, it was further stated that in view of above, it was decided that the required amendment in the rules would not be required. Paragraph, producing the copy of the Karnataka Nursing Council rules, it is further covered in paragraph 6 as under, and bracketed portion is start as in terms of the national nursing rules. Accordingly, not midwifery commission, paragraph. In view of, after quoting, in view of what is stated herein above, there is no willful disobedience of the directions of learned single judge. The contempt petition is not liable to be entertained. It is dismissed accordingly.
I may be given liberty to challenge the proceedings, the decision taken by them.
Court proceeding to which
They have taken a decision now not to make recruitment. That decision, I've got a right to over that post, my lord. Your last may permit me to challenge the proceedings.
Petition is not precluded from challenging any decision which may be adverse to him in accordance with.
Seven by 86, H.C. Seven by 86, H.C. Shivram.
In this, I appear for complainant, my lord.
Hmm.
Can I come?
Who?
Your lordship permit me to come and argue the matter, my lord, before physically, my lord, tomorrow or day after tomorrow, any day convenient, my lord.
Hmm? You want tomorrow?
Tomorrow or day after tomorrow, my lord. If possible, tomorrow or day after tomorrow, any day convenient.
The request of learned the petitioner stand over to 22nd November.
Grateful, your lordship. I'm very grateful.
Number 87.
I appeal for the petitioner, my lord.
But this, the contempt against the first respondent union will have to be closed. My lord, in the writ petition, Union of India was the first respondent, and a certain company called Hindustan Paper Corporation was the second respondent. The writ petitioner's grievance was that some interest had to be paid by that company. Not while disposing of the learned single judge, in the last para, indicated that complaint shall be made by respondents. Therefore, my lord, contempt initiated against me. I had filed a review. This morning, my review was allowed, and the direction to me has been confirmed. So, in view of my allowing of the review, proceeding against me will have to be dropped.
My lord, one submission, my lord.
I'll produce just this morning, my lord, it was allowed. But my learned friend is present. He was present.
The review petition is allowed, my lord. It is true that review petition is allowed.
So contempt against number 1 is to be dropped.
Please, my lord. In addition to that, petitioner is taking steps to challenge the said order. For the time being, contempt proceedings may be disposed of. May be disposed of with the
entire contempt proceedings will have to be closed because the second respondent company is wound up in 2018. No point in prosecuting.
And the following were the directions passed by learned single judge. In respect of it, the present contempt petition is filed. Then court bracketed portion, page 20. When the petition came up for consideration today, 2 developments were pointed out. Learned Solicitor General of India, Mr. Kamath, stated that respondent number 1, Union of India, held a review application in respect of the aforesaid directions in the order. So, it was undisputedly stated that the review application is allowed. In that view, Pereira, the contempt proceedings will not survive against respondent number 1 union only. Full stop. The second party, the second respondent is Hindustan Paper Corporation Limited, which is a company already wound up
In 2018.
in 2018. In that view, the contempt proceedings will not survive against the said respondent also.
Liberty may be reserved to the
This
petitioner
petition
to
is
challenge the
I'm grateful.
as not surviving.
liberty to the petitioner to challenge the review
88.
order, my lord. That may kindly be reserved, my lord.
What is to be challenged? Review no order, you can challenge
Please, my lord.
in accordance.
Please, my lord.
88.
My lords,
88.
my
What
lords,
is it?
I appear for the complaint. The order of which disobedience is alleged, my lords, is annexure A, page 11, my lords. Lordship may kindly, page 11.
Page
11.
11.
That is annexure A. That is the order of which disobedience is alleged. Your lordship got it, my lords. My lords, your lordship will see the first petitioner is Uma Devi, my lords.
Hmm.
And thereafter, my lords, your lordship may turn over to the next page, my lords, page 12.
Uma Devi.
Uma Devi is the first petitioner.
Same 2006 4SC page.
My lords?
Yes.
She is not the one, my lords. She is by name of same person, but she is asking for the same relief of regularization.
In lighter way, yes.
My lords, next page, your lordship may kindly see, my lords, at page 12. There is a connected writ petition.
Hmm.
Siddhappa, Boramma, and Basuraj are the petitioners there. These are the connected writ petitions. My lords, this came to be disposed of by a common order. Order your lordship will get at page 20.
Page 20.
Yes, my lords. 20. Ink page, running page 20. The order only said, my lords, that the issue has been dealt and covered by this honorable court's judgment in WP number 3672 of 2021. So take necessary action similar to that of in 3672 of 2021. What happened there, my lords? All the petitioners got regularized. Even in this case, my lords, I pointed out this petition complainant is Uma Devi, and the other connected petitioners are Siddhappa and others. They are all regularized. But so far as Uma Devi now, my lords, they are not regularizing. Your lordship may now kindly take annexure. Page 94, my lords, which is the translated copy. In page 94, your lordship may kindly come to page 102. This is the order where they are, in pursuance of the directions of this honorable court, they regularize the service. Page 102, my lords. Siddhappa, Boramma, your lordship will see that person name. And the order is that your lordship will get at page 104. 104. In the last paragraph, in the light of the details mentioned in the preamble and as per the orders passed by this honorable court in WP number so and so, the services of the following temporary pay employees of the Mysore City Corporation are regularized with effect from the date of completion of 10 years of service, and following the service benefits are granted to them, and they are all regularized. Siddhappa, who are part of the same writ petition, same order of this honorable court, they are all regularized. And page 105 is the benefits which got extended. And so far as the Siddhappa and others.
Well, then why this?
This, my lords, now they are declining to regularize and they are taking a different stand. This is nothing but aggravated contempt. Part of the order, petitioner of this very same writ petition, they comply, regularize.
Yes.
Now they can, this is.
Instructions. Affidavit has been filed, my lord. There has been office objection has been noted.
Affidavit they file. In the affidavit, they say rules does not permit. This is nothing but aggravated contempt. They have filed an affidavit. When part of the same writ petition order, other persons have been regularized. They cannot take a different view for this very person and say something else. It's case of aggravated contempt, lords. They cannot circumvent the court orders by merely issuing endorsement when they comply with the part of the court order. Therefore,
where is your affidavit?
which one, my lords?
Lord, filed on 17th September 24, man.
Here annexure R1 they have given. Page
Para
6
4
of
and
the
5.
endorsement.
17 September. What
Please,
did you-
my lord, para 4 and 5, my lord.
What do you say?
They note this case number and say that last para 7, my lords, the last paragraph, page 7. In view of the directions of this honorable court in WP 3461 and as per the government circulars, since you have appointed as daily wages employee after 1186, there is no provision. From where this is flowing, my lords, they cannot take, they are not sitting as an appeal. They are not division bench. The authorities are acting as if they are the
We'll
division
call
bench.
this under secretary here and make them comply with the order.
My lord, I will file a better affidavit.
They are not there.
Because if you see page 84,
I understand.
there is a deemed regularized. Whether you pass order or not, court is regularized. So how can you take a different stand absolutely contrary to the direction?
We'll file a better affidavit.
Not
2 weeks
better,
time may
they
be
are
granted. my lord.
comply. They are acting as if they are the division bench. They are not appellate authority.
Better affidavit.
They are not.
Government is full bench.
Now give us some time, my lord. We'll look into it.
Yes,
and-
unless we have to be strict, you. Yes.
Please, my lord.
Will not keep beyond 12th of. At the request of learned additional government advocate, Mr. Harris, stand over to 12th
Both
of
the
November to be listed at 2/3.
Please.
That next matter also same, my lord. Same.
89.
Same order.
Grateful. Deeply obliged.
Number 90, Jagdish Shastri.
Lord, the complaint is taken back for river.
Complied with.
Complaint, but they are taken back my work. Yes, my lord. They are
Learned
taken back.
advocate Mr. So-and-so states that the order and contempt is complied with. In that view, contempt petition does not survive. It is accordingly dismissed.
They are taken back for rework, my lord. They earlier relieved from me, but they are now once again they are taken back for work.
Either mic is not clear or your voice is not. Done, chal. Take one wrong order.
But not, they are not ready to pay me salary.
It is no ground.
Salary is
Late
not.
compliance is no ground in contempt. Next. chal. 91.
Number 91, Shetty Deepak. 91.
Line.
For the fourth respondent, my lord. I pay for the fourth respondent. And I filed my objections, my lord, in the office last week. Appears it is not put up, my lord.
Who here, please?
Mr. Deepak Shetty.
December. None present for the petitioner in that view. Stand over to 5th December.
Oblige.
Number 92, Mr. Chandan K.
May I be pleased, my lords, I may be permitted to appear on behalf of counsel for the petitioner.
On behalf of petitioner.
Indeed, my lords, Mr. Chandan.
What is
Let's,
it?
let's, in fact, this writ petition was got dismissed earlier for non-compliance of the office objections, my lords. The objections are concerned to get the eligible copies of annexure B, E, F, G, my lords. But those are the tender document, my lords. It took me a bit delay to get those documents are concerned. And the second reason is also, my lords, my own house got in the floods, so I couldn't secure the documents at the right time. So I have filed a recall application today to restore the writ petition is concerned. If my lords so pleases and grant me 2 days time, I'll comply the office objections
and I'll appear physically to argue the matter is concerned. Matter is pertaining to the tender notification issued on 18/12/2023, my lords. Even after making a representation that there was a fraud committed by the unofficial respondent in securing the tender by forming a cartel, the department, without considering the representation, is favoring towards the unofficial respondent is concerned, my lords.
Now, company is filing public interest petition.
Indeed, my lords, the reason is this. The present petitioner company, my lords, also
Hindustan-
provides a contracts, my
Hindustan
lords.
Technologies.
My lords.
This
Hindustan Technologies company, my lords, it also participates in the tenders of the shipyard, my lords. So the grievance of the petitioner is this. And lords, as the lordships are well aware that the PIL can be filed. The grievance is this, my lords. The workers of the present company is also works in the ship
It is,
repair works, my lords. So if such and such
even-
notification,
Even
my lords.
otherwise, the tender was issued in December 23. Now, what survives?
My lords, the December notification is on 18/12/2023. But the process starts in the year 2024, January, February.
You come physically if you are in Bangalore.
Indeed, my lords.
When do you want?
My lords, day after tomorrow would be suffice, my lords. I'll
Not day
appear.
after tomorrow, not day after tomorrow. 12th,
My lords.
12th.
My lords, a specific date maybe.
This is for restoration.
Yes, my lords, it is coming for the restoration of the writ petition. As it was dismissed for office objections are concerned.
IE number 2 of 24, heard
Indeed.
for the respective parties, this application is filed seeking to restore the writ petition number 1373/4 of 24, which was dismissed for want of prosecution. Full stop. In order to enable the applicant petitioner to contest his case on merits, rather than being thrown out on the technical ground of dismissal for non-prosecution, the petition is restored to its original file along with all substituting orders. Petition may be listed on 14th of November.
Deeply obliged, my lords. Obliged, my lords.
Recalling your please belong. Delay. Be passed on.
Number 93, Mr. S.B. Mukkanappa.
Service awaited. In view of the endorsement on the board about the service having been not effected, then over to December 12.
Number 94. Mr. Varun
Appear for the
Jacob.
appellant, the maintainability of the writ petition. Writ petition was filed under, along with 482 CRPC. The appeal is not maintained. The office has raised objection. But I am representing the enforcement directorate. Our summons issued in December 23 was under question, a mere summons.
I'm ready with the matter, my lord. There's no difficulty. It may take some time. I'm ready with the matter. It may take some time.
Lordship may have it any day at 2:30, my lord. 23 mere summons. Single judge has dismissed the writ petition. The office has raised an objection regarding maintainability. May be heard at 2:30, my lord, any day that your lordship finds convenient. We are not able to proceed with the investigation, my lord, because there is an interim order. And the interim order was granted on the sole ground that the copy of the impugned order was not available on that day. Without producing the impugned order, the writ appeal was filed. Awaiting the production of the impugned order, there was a limited indulgence shown on that day.
We have produced the order copy later. I have also filed an application for amendment that is also listed.
Petitioner is
Please,
petitioner is ML.
no,
No, my lord, he is the
not
chairman of a district cooperative bank. And the allegation is that he will take gold to issue loans.
Whenever you will take up a 2/3. When do you want?
Would anytime next week,
13th,
I'm 14th,
14th or 13th?
13th,
13th.
I'm grateful. Would your lordship have it at 2:30?
2.
I'm grateful.
interim order may kindly be continued.
Or to 13, to be listed as 2:30, as per the request jointly made by both the learned advocates. Interim order shall continue to operate till the next day.
Number 95.
Appear for the appellant in this case, my lords. I pray for a week's time, my lords, to comply with office objections.
3 weeks are granted to comply with the office objections. Adjourned accordingly.
Grateful, my lords.
Number 96.
Appellant in this case, my lord. A week's time may be granted for
96.
complying the office objection.
Same order. Same order.
Obliged.
Furnishing of process fee, etc. Till number 97.
Lordship, in this matter, in fact, the government has submitted the compliance report for which I have already filed my rejoinder stating that it's in a partial compliance, wherein your Lordship, in their own statement of objection, they have pointed at para number 5. In one breath, they would say that, your Lordship, that is, there is no stream as such. But after the joint survey, your Lordship, in their own statement of objection, in para number 5 at page number 3,
It is for hearing or for?
Lordship, that process, insofar as process is concerned, since it is an agam, yes, please.
What do you?
Lordship may have it week after next, my lord, not have the
You want your paper?
week after next, please,
After week,
please.
23rd November.
Please.
No, 25th November, sorry. 23rd is Saturday.
Please.
Number 98. Sanjeev BL.
The order was passed in February 27th, they cannot being deprived of the appointment.
There is a delay.
Senior is some personal inconvenience. Senior couldn't come, my lords.
You want
Kindly
time?
take it up next
You want time?
week. Yes, ma'am.
26th November.
26 now. Grateful.
My lord, comply the order.
Both together.
Yes, ma'am.
So 99
Number 99, office
to
objection.
99 to 100, for 3 weeks time is granted to comply with the office objections. Then 101 to 111.
111, my lords.
110. 3 weeks time is granted to comply with the office objection. 111, yes.
111, my lord, I appear for the petitioners in this matter. My lord, office has raised an objection saying that accused number 1 and accused number 3, they were not parties in the writ petition, my lord. But it is a respondent is a bank, and the accused are the MD, who is an officer in charge of the company and very much aware of the orders of this honorable court, my lord. And accused number 3 is the immediate branch authority, my lord.
Bank officer.
Yes, my lord, they are bank officers, all of them.
Pending office objections are dispensed with, subject to further consideration, the petition may be posted
Please, my
for
lord, please,
admission
please. The date may please be given,
after 2 weeks.
please.
Finalizing matters, 112, Mr. Vasant Aditya. Mr. Vasant Aditya.
The petition is of 2015. Nobody is present when it was called out. It could have been dismissed for want of prosecution in the larger interest of justice, tend over to 26th of November.
My lords, with my lords, kindly serial number 111, my lord, the previous matter.
26th November.
Lord.
111 or 26th.
Serial number 111, the previous matter, my lord.
Yes, 26th November.
Yes, my lord. Writ appeal is also filed by the bank.
Yes.
May I request my lords to connect that matter?
113. Follow.
Serial number 113, Mr. Sachin BS, the final hearing matter.
So same order in view of awaiting the presence of learned advocate for the petitioner in vain, stand over to 27th November.
Add one submission. Add serial number 59. Please urgent, my lord. Next week it may be posted, my lord.
It is already posted to some date.
Civilly situated or granted substantial, my lord.
Pardon?
Suffering cease from 8 to 9 years, my lord.
It is already posted when it was
Please, my lord, next week it may be.
not posted.